Any mention?
Please, Your Lordship. Lordship, I beg to mention and one unlisted motion for today, Lordship.
What's the matter about?
It's regarding auctioning of a market, Lordship.
Which market?
This Omdolun market, Lordship.
Umdolun
The auction is tomorrow, Your Lordship, at 9 a.m. In fact,
why are you challenging it?
In fact, I am the successful bidder. I've been running the market for almost 1 month now. Now the respondent has issued a fresh auction notice, re-auctioning the same market.
Noble support. That means noble support, right? Yes.
Lordship, I have a prayer that if the matter may come out at 2 o'clock, Lordship. At 2, Lordship. Second half.
It's not been filed as yet.
It's in the process of filing, Lordship.
Take a chance. If you can't do it by 2, then before I rise, then too bad. Yes.
Lordship.
Yes.
May please, Lordship. Lordship, I beg to mention item 19. Item 19.
What happened, item 19?
Lordship, I pray that this matter may be taken up after 3 weeks, Your Lordship. The conducting...
The same contempt matter?
Yes.
I think better... Are you still interested?
Yes, Your Lordship.
Lordship, after
you
3...
got compensation? The mother didn't get any compensation?
No, Your Lordship.
I can't keep to 15 matter like this.
Lordship, after we will do it, we'll inform our...
Do it when?
We'll inform the conducting council and then...
Who's the conducting council?
S. Chakravarti.
He said after 10 May, I saw him in court yesterday. All matter he said that he'll be out of station till 10th of May. 1 week, okay.
Lordship, 3 weeks, Your Lordship.
You argue matter, 2 weeks, okay. Right.
Okay.
How many months you practice or years?
1.5 years.
Oh, that means you're more than competent now. Yes.
Okay,
You can argue it, no?
I'll take instruction from the conducting council, senior council.
Okay. Argue it. Yes. Take the chance if your senior is not there. Yes.
Please, Your Lordship. Your Lordship, I beg to mention item 24 of the hearing list.
24?
24.
No objection, Your Lordship.
2 weeks, yes.
23 also is connected, Your Lordship.
20?
23 is connected, Your Lordship.
23 is who's the petitioner?
I've not seen him today, Your Honor.
Who's the petitioner? It's connected to 23.
23 and 24, Your Lordship, are connected.
You are appearing in both the matters?
I'm only for 24.
Then you consult first the other 23. You mentioned that time, yes.
Your Lordship.
Yes.
My Lordship. Please, Your Lordship. Your Lordship, I beg to mention item number 22, Your Lordship.
Making a joint prayer, Your Lordship. We're making a joint prayer.
Yes?
We're making a joint prayer, Your Lordship. Joint prayer, Your Lordship.
Oh, joint prayer?
Yeah, after 2
Okay,
weeks.
1 week,
Lordship.
yes.
Much obliged, Lordship.
Your Lordship, I beg to mention item 29. Lordship, we're yet to get instructions from the client.
29, what is it?
It's a Christian Academy matter, Your Lordship. I've informed the other.
Oh, okay.
Let 3 weeks be given, Your Lordship.
3 weeks?
Yes, Your Lordship, because I have to, the office bearers will have to come all together to meet with us, Your Lordship.
Okay, 3 weeks.
Highly obliged.
Yes, make it quick.
Your Lordship, I beg to mention item number 30, Your Lordship. 30.
30?
Yes.
32?
No, 30, Your Lordship. Let it come after 2 weeks, Your Lordship.
No objection, Your Lordship.
2 weeks, okay, 2 weeks, yes.
All right.
Yeah, please, Your Lordship, I beg to mention item number 35.
30?
35, yeah.
Let it come after a week, Your Lordship.
So what is it about?
This is a matter where a formal suit was filed. Already decreed.
34?
35, Your Lordship.
Oh, yes. Who's your senior?
Mr. Echnoklau.
Echnoklau.
1 week.
Highly obliged.
Please, Your Lordship, I beg to mention item 26.
Number? There's some urgency in the matter. There's no urgency.
This is amalgamation, my lord. Amalgamation of 2 villages.
1 week.
Yes, Lordship.
Yes.
Highly obliged.
Yes.
Should I beg to mention item number 25, Lordship?
20?
25. I'm praying this matter will be taken up after
whose
10 May.
behalf? Who's leading you in the case?
I'm Mr. L. Songwan, Your Lordship. I'm from the petitioner.
What's the matter about?
About the house letting about
On the bank of the river?
Yes, Your Lordship. I mean through river.
1 week, okay. Yes.
Oblige, Your Lordship.
Supplementary list.
Apologies, Lordship, beg to mention item number 31. This matter, my Lord, as per Lordship's last order, respondent, the UGC was supposed to take instructions whether they want to file an affidavit or not.
Yes.
My Lord, I have sought instructions. Affidavit is not required by the UGC because UGC has not prescribed any maximum age criteria. It's the state government which has prescribed by way of a notification. So the state government has to satisfy this honorable court whether
What's
they...
the matter about?
Appointment of assistant professor, my Lord.
Is Navin Chhetri?
Yes, my Lord.
So what do you want today? To take it up?
Because they were supposed to take instructions on whether or not to file.
No.
If her instruction is that they're not filing.
Then we'll post another date. Yes, MSP P. Agarwal, on behalf of respondent number 11 submits that instructions that no affidavit be forthcoming from the said respondent. Stop and review the matter. Post this matter for hearing after 2 weeks. Okay, 23 matter. Yes.
Supplementary list. Item number 1.
Please, Your Lordship. Your Lordship, this is a transfer petition. Initially, we have preferred a civil appeal before the Learned District Council Court.
This one and 2.
Yes.
We have to go to another bench.
Regular court.
Now, I've recused from the main case. Yes.
Yes, Your Lordship.
This is matters. This 1 and 2. You appear in both the matters.
No, only in item number 1.
One. This is matter before. Any other bench wrote me. Bracket HS. Thank you. Similarly in 2 also. Yes.
Much obliged.
Item number 3.
Good morning, my Lord. My Lord, the matter pertains to the non-payment of outstanding bills for works which have already been executed. My Lord.
Where's the state? Who's the previous matter?
Which matter is this?
Natalie Dawn.
I'll appear for now, Lordship.
Oh, Mr. Karon Lang. Yes.
Lord. Lord, the petitioner is a contractor who has participated in the tender process which was initiated by the respondent number 1, my Lord.
When was the tender floated?
My Lord, it was floated at... my Lord, at Annexure 1 we have received the letter of acceptance, my Lord, for the tender, having been successful.
Construction of what?
Upgradation of a road segment as well as a construction of a RCC bridge, my Lord.
Okay.
My Lord. My Lord, the tender, if I may take your Lordships to Annexure 1, which is at page 17 of my petition, my Lord.
Yes.
My Lord, if I may read, my Lord.
Because online, so. One courier requested to, okay, fine. So you did the work?
My Lord, yes, my Lord.
That is 2019?
Yes, my Lord.
So when do you complete the work?
My Lord, the construction itself, the upgradation, the tender itself involved 2 segments. The first segment is the construction of a road from Kinchi to Lauberton, which is almost 3 kilometers long, as well as the second segment being the construction of an RCC bridge. So the first segment of the construction, my Lord, was completed in February 2022. My Lord, if I may take your Lordships to Annexure 2, which is at page 19. After being awarded this, my Lord, the respondents had issued this letter to us for to proceed with the work, my Lord.
Yes.
Now, for the project itself, my lord, and the project itself was the respondents had prepared a detailed project report, which is annexed at Annex 3.
One thing, Mr. Missel.
My lord.
Now you finish the work.
Yes,
now your prayer here is that they've not cleared your bills.
Yes,
Any certified bills are there?
Pardon, my lord?
Any certified bills are there that they owe money because they come by writ jurisdiction.
Yes, my lord.
To make them, to compel them to pay.
Yes, my lord.
So that's the thing. So when did you complete the work?
My lord, the first segment we have finished in February 2022.
You handed over to them.
Yes, my lord. And
They've accepted it. That is
my lord, there was several correspondence with the respondents where we had raised several issues when it came to the construction with relation to the second segment of the construction, my lord.
Well, it took time to.
My lord, in Annex 4, if I may take, my lord, at page 38, we had given a letter to the respondent that we have received a detailed project report with regards to the road construction as well as the bridge construction. So for the road, my lord, we had prepared, we were ready and prepared to construct the road, and we had continued with the road as well as made efforts.
Okay, just tell the court one thing. Now, after you ordered a contract, notwithstanding all these little hiccups, the work was complete.
My lord.
Everything's finished.
My lord.
Upgraded, the road's been upgraded.
Yes, my lord.
The bridge's been constructed.
Yes, my lord.
Then what happened after that? They're refusing to pay your bills.
No, my lord, there's no response from the respondents, my lord. We have submitted the running bill for the first segment.
Take instruction in this matter.
How is it possible?
Yeah, that's
the
why.
works awarded, and if the works complete.
No, my lord, I have to take instruction, my lord, in this matter.
Is it a formal tender?
That is what I am trying to look. If your lordship will see this is Pradhan Mantri Gram Sadak Yojana program guidelines are there. My friend has placed at page 58.
See, accepted your bid cast online. So this is under this PMGSY tenders.
Yes, my lord.
And you take instructions?
I will take instruction.
Mr. Sonso, issue notice returnable in 3 weeks. MS, who's accepting notice? Mr. Kharwanlang. So with Mr. Advocate General with so is present on behalf of all the respondents. No further notices called for. Yes, after 3 weeks. Yes. For instructions, affidavit.
Item number 4.
Yes, I have already made. I have made an application to implement the central government as.
Where's the application? High application. In this case? Yes. Newly implemented.
Union of India.
It'll be response number 6. And National Highway Authority of India, 7.
Yes.
For this case, number 60, 2024, and WPC 124, 2024. There's an application for implementing the Union of India through the Undersecretary, former Ministry of Road and Transport, Communications.
Yes, ma'am. They are writing like that only.
Communications, Common New Delhi, and to National Highway Authorities of India, New Delhi. The same like was not objected to by the other respondents. It appears also that the necessary parties accordingly. The Union of India so is impeded as number 6, and National Highway because of India is impeded as number 7 in the main writ petition. Registry to make the necessary corrections in the cause title for additional respondents. In the main writ petition, in view of the order dated passed in Ms. Case so issue notice to the newly implemented respondents of However, MS A. Pradhan, who has entered appearance on behalf of said respondents. So no further notice called for. Yes, what do you have to say?
No, here, my lord, only limited prayer, my lord. Before there is so many persons, land was encroached. So they have got the compensation. Even my land also encroached. So they are not taking any action. So previously we will file a writ petition. In the writ petition, they have given a direction to make an export inquiry and pay compensation if they are entitled to these things, my lord. Accordingly, an inquiry was conducted on 3rd May 2023, my lord. After that, the district collector, the DC, has not taken any action. That is the reason we have to compel to come here.
With regard to the merits of the immediate petition, it has been submitted that the petitioners agree with the non-payment of compensation.
It's not, Your Lordship, non-payment of compensation. If Lordship kindly come to the order dated 20, at page 20, that is the order dated 14/8/2019.
20.
Lordship,
Page 20, sorry.
Lordship, page 20. Lordship kindly come to page 21 at paragraph 4, Your Lordship.
Yes. What decision is this?
If Lordship allowed, I'll read it, Your Lordship. Reference was made to the operative 9 and 10 of the decision, which read thus: the petition with the consensus of the Land Council for the parties are disposed of with the direction to the Deputy Commissioner William Nagar to specifically look into the issues whether any portion of the land or the property of the petitioner exists or existed adjacent to the national highway which has been constructed from Tura to Shillong. In case, answer shall be then as to whether the petitioner have suffered any damage due to the construction or in the process of the construction of the road. Lordship is claiming for damage, Your Lordship.
No. Thereafter, my lord.
Fine.
Most
Nobody
probably,
is, even if the land's taken,
Lordship, yes.
they have to compensate for the trees or for the building if it's been damaged.
Lordship, most of the soil must have been thrown to the land, Your Lordship.
And moreover, the inquiry report.
What is liability?
It must have been, Your Lordship. I don't know, Your Lordship. That is for the National Highway Authority to explain, Your Lordship.
Naturally, then.
I'll have instruction, Your Lordship. So far as
liability and
I'll have
absolute
instruction, Your
liability.
Lordship.
If you are making a road, absolute liability lies upon the people doing the road. It's a question of strict liability. So if it's, it's collateral to whatever happens, yes. Mr. Belon, Council Petitioner, that the petitioner, that the petitioners aggrieved with the inaction of the respondents pursuant to an inspection and spot inquiry which was conducted on
3rd May 2023, my lord.
3rd of May 2023. Next paragraph is initial and EAG as also the funds to obtain instructions or to file affidavit.
Only Lordship will kindly observe that the maintainability of the writ petition, Your Lordship.
Maintainability?
Lordship, yes.
Now the only remedy is that if this kind of things, it's rampant now. People's cultivable lands being destroyed. When they make the road, they have no care for environment. They dump the refuse into the water while making the roads. Some people now, they've been denied of cultivation. They've been cultivating maybe oranges and all for hundreds of years. They just water source go and become big. In the guide of development, now you're putting this, you're driving people to poverty.
The list item number 1.
Yes.
Lordship, I'm praying for some time, Lordship.
Why?
Lordship, this is sensitive.
You're the lead counsel here as per the last order.
Lordship, I just appeared. Lordship, this is a sensitive matter, so...
Now that, what? It's over, delimitation process.
No, it's going on.
When will it get completed?
It will take some time because the Southwest Castle is still pending. Here we are just raising the issue of locus of the writ petitioner. We are not going into other issues.
You ready on that part regarding locus?
No, Lordship.
Who is he? We want to know.
He said he's an advocate, right?
It's not there. She does not know.
Your Lordship, Mr. Paul will be in a better position to address that matter.
Yes, MS B. Karwanang, the council prays for some accommodation due to the unavailability of the senior arguing counsel. Stop and consideration thereof listed after
2 weeks.
3 weeks.
3 weeks.
Lordship.
By that time we'll be prepared.
Yeah.
Yes, 3 weeks. Yes.
Highly obliged.
Item number 2.
This is relating to border issue, my lord, but which is matter is pending before honorable.
Could you order minute? Same one. After 8 weeks, yes.
Obliged, Your Lordship.
What's happened to the matter there?
It's still pending.
Not taken up at all.
And not a date was fixed, but Supreme Court is sitting 9 judges bench for last. All constitution bench matters are going on for last 2-3 months. Therefore,
Private assets.
Yes, that matter is going on.
Yes.
Item number 3.
Lordship, that respondent, private respondent yet to file the affidavit, that is respondent number 8, Lordship. Private respondent number 8, Lordship, yet to file the affidavit, Lordship.
Where's number 8?
Sometimes they appear, sometimes they remain absent, Lordship. Again they will file, they will come with the petition. One more last opportunity may be given, Lordship.
So time was sought by the council 1B8 on the last occasion for filing affidavit to the none appears on their behalf. You already filed affidavit?
Yes. They have filed.
Yes. However, in the interest of justice, this is matter after 2 weeks for affidavit. Yes.
Otherwise, again they will come with
which they shall not be permitted to file affidavit any further. Yes.
Item number 4.
Affidavit file.
Lordship, I have to pray for some more time, my lord.
Who's the concerned officer who sent that last instructions to the senior government advocate, the cryptic one which is recorded in the order?
Lordship, it's the Deputy Secretary, Personal and Administrative Reforms B.
Does he need to appear in person to explain?
No, Lordship.
Otherwise, at the request of so-and-so and on the prayer of so-and-so, then senior government advocate, further 2 weeks time granted for filing affidavit.
Much obliged, Lordship. Item number 5.
You tell them if they don't file it, then they'll have to appear personally to explain this.
Accordingly, Lordship. Much obliged.
Please, Your Lordship. Your Lordship, the Union of India is yet to file affidavit. The state respondents are pro forma. The main is Union. This affidavit was withdrawn due to some error, and then this is that matter, my lord.
Then you drew the affidavit and you have not filed a fresh one?
Well, we prepared it, but there's some problem with the nature of the affidavit. Some more time is given, my lord. We'll file it by next time.
Why do you withdraw the earlier one?
The name of the Lieutenant Colonel was not mentioned in the affidavit. It was just written, I, Lieutenant Colonel, so and so.
And it's accepted by registry. What was the name of the deponent?
No name was there, my lord.
It was written as Subhidhar Adjutant. Subhidhar Adjutant.
Anyway, appropriate for the 2 weeks time granted to the respondent number
120.
1 to 3.
to file affidavit.
Lord, it may be as last chance, my lord.
You already got affidavit. They're not going to change the contents.
Item number 6.
So you know you can prepare a rejoinder in the meanwhile.
Obliged, ma'am.
What's the matter about MS Raji?
May it please, Your Lordship. Your Lordship, similarly, I'm praying for some more time in this matter also. We'll file a concise and precise affidavit, Lordship.
Straight for the 2 weeks time granted to the resident senior GA. File affidavit.
Item number 7. Much obliged, Lordship. Lordship, in this matter, they're supposed to file a rejoinder, Lordship.
Lordship.
Who are you? Okay, Mr. Kharfa for number 5. What about state?
We've already filed.
Your Lordship.
Rejoinder, you're not filing?
We're filing, Your Lordship.
You're filing?
Yes, Your Lordship.
Mr. E. Kharfa for 5 prays that the required instructions and documents are received. He prays for and is allowed 2 weeks time to file affidavit. So, similarly, Mr. Tingdo, on behalf of parishioners, is permitted to file a rejoinder to the affidavit of the state within such time.
Much obliged, Lordship.
Item number 8.
My Lord, here, my Lord, we have come against an execution order passed by the commercial court, my Lord. My Lord, now we are ready with the money, my Lord. So I may be permitted to withdraw this. We will deposit the money before the judge commercial court, my Lord. But only one observation by your Lordship, my Lord, that we have filed an appeal against the decree, my Lord. That should be taken up and the money will remain in the court, my Lord. After that appeal.
Where is that?
My Lord?
No, my Lord, my Lord, I have little objection here.
Yes.
My Lord, I am appearing for the decree holder.
Yes.
And if this award, my Lord, was passed as far back as in 2003.
Yes.
After that, they challenged the award for setting aside the award. That was both the matters that was rejected. Then we filed execution in 2018. They just sat over that. They never challenged that order. And in the execution, my Lord, court was pleased to issue notice to them to file show cause why the award should not be executed. They filed their show cause. In that show cause, their only contention was what is the awarded amount. They were under their contention is awarded amount is only the principal amount which is awarded, not the interest which is pre-reference and penalty-like interest which the arbitrator awards. That cannot be part of the award, according to them. And that matter was heard at length by the executing court, and executing court rejected their show cause, their objections. By order dated 25/9/2023. They never challenged that order. They never challenged that order, my Lord. And from time to time, they kept on assuring the court that we are going to deposit the money. The executing court was pleased enough to give them time. More than 3 months' time was given to them. Every time they say, keep file is under process, money has come, next date we will deposit, give us 1 week time, like that, it carried on. And finally, after 3 months, when they failed to deposit, they failed to even produce a document that the money has been sanctioned. The officers themselves appeared before the court, but they did not show anything whether the money is going to, money has been sanctioned or not. That is why the executing court passed the order for proceeding with the execution.
Now what is the challenge?
Now the amount has been sanctioned, my Lord.
Now, even before this honorable court,
Yes.
my Lord, even before this honorable court,
Yes.
on the past occasion, my learned senior counsel had submitted that they are going to make the payment within 2 weeks. 2 weeks is over
No,
till
forget
date.
about that. That's water under the bridge. I'm talking about as on today. Now, what is the
Yes, my
situation? Now they said the deposit the total amount.
My Lord,
Now, have you challenged the award?
My Lord,
we have challenged, my Lord.
My only submission is that, my Lord,
One second.
what my learned,
You want to withdraw the amount? You want to withdraw the amount?
yes, not
my
to
Lord, kindly
withdraw.
turns to page 73, my Lord.
Your Lordship.
You want to?
It is up to the executing court, my Lord.
Exactly.
If the deposit
Exactly.
level-
The executive court to pass any orders. That because that is
Yes.
the matter there. Yes. You've come with a limited
no
prayer.
observation should be made. That is what is my submission,
Against
my
me,
Lord.
like what, locking up the office, correct?
My Lord.
Yes, that's
Against that we came, my Lord. Now the amount has been sanctioned, my Lord. Our appeal to the same decree is pending before the same court, my Lord. Same commercial court, my Lord.
That you take it up there. That's all. Let them pass orders as in accordance with law.
So I'll simply withdraw, my Lord.
No observation may be made, my Lord.
Yes, Dr. N. Mozika Almed JCI submits that as the decretal amount has been sanctioned, be deposited in executing court, nothing survives for consideration in the present petition. Accordingly, matter stands closed on withdrawal. Yes.
My Lord, within
we'll deposit proceed in accordance with law.
We'll deposit within 15 days, my Lord.
Again, they are asking for this.
The praise
That
was not
15 days.
nothing remains constitution except for the time period of 15 days to deposit a set amount. Prayer is allowed executing court to thereafter pass orders in accordance with law. Yes.
Till then, till we deposit, no courtship action, because that is the attachment of warrant attachments are
15 days you've been given,
Neither they
15
will
days.
deposit.
You can take this order and show
Neither
to
they
the
will
court.
deposit the money, nor they will allow the
only
execution
till
to
then,
proceed.
till the money is deposited, they will not take any courtship
Okay,
action.
I'll correct. We'll do the order. Yes, next.
Item number 9.
Yes. You've taken steps.
Yes, my lord.
No one's appeared.
Mr. P. Nongri was appearing before.
No, there's nobody here. There's a fresh
Petition, yes. File the press.
You have not taken steps as per office note. What is it, Mr. Bora?
Before filing, the copies were served to Mr. Nongri.
Served to whom?
Served to Mr. P. Nongri.
No, you got a wrong case. That's a different case. That was
I served
yesterday.
it today itself.
He's not appearing. This is an entire fresh matter. You've not even taken any steps.
I'll take steps today itself.
Actually, delay 2010 days. How will we condone also? It's a different case altogether. Why didn't take steps?
My junior said she had issued copies to Mr. P. Nongri because he is appearing in a CRP.
Let's just matter after 1 week.
I'll take steps.
To enable Mr. Bora to take steps.
Item number 10.
My lord, the state have filed the affidavit.
And file a rejoinder.
My lord, a rejoinder may not be required here.
Then who's this SMLM who took time last time? If rejoinder not required, don't make a prayer because the case get unduly delayed.
My lord, I apologize, my lord. Now, my lord, now they have...
A rejoinder is not a matter of rights. Only that even when the council prays that rejoinder is allowed by the court.
My lord.
Yes.
So here, my lord, they have given a water connection to the village, my lord. But the irony is, it's not simply not working. No water is coming to the village. Now what they are doing is, they are pumping the water from 4 kilometers downhill, my lord. And 1 week they have been pumping, and it's not even filling half of the water tank, my lord. And we are like 100 plus.
Village.
Yes, my lord.
But they've been pumping for 1 week.
1 week, and it's not coming, my lord. They have spent a lot of money. That's we appreciate. But the thing is that the purpose is not getting solved.
So can this court go into that whether the engineering concept was right or wrong in providing water to your village?
No, my lord. Simply what my lord has directed in the first place. My lord, this kindly appreciate, these two villages is in the plateau, my lord. We are sharing 2 villages in the plateau.
It's on top of the mountain.
Yes, my lord. So the only source of water that for both the villages is one only, my lord, which we have been sharing since time immemorial, my lord. Now they're saying there's some dispute. Of course, there is a dispute as to the ownership and title of the area, my lord, of that area. But my lord, the water, my lord, the water that we have been sharing with each other since time immemorial. Now government has clearly admitted that the pipe that goes to my village has been destroyed by some miscreants, my lord, twice. So that is the reason why, my lord, we have come, because we say that we are not getting the water. And my lord has said that the respondent shall try to resolve the disputes regarding.
Where's that order?
That order is the first day itself, my lord. There's 14th February 2024, my lord. The next page, my lord, it is said, it is further provided that notwithstanding the pendency of this writ petition, the state respondent shall try to resolve the dispute with regard to the sharing of water equally, so that no villagers are deprived from using the source of water for drinking and other purposes. Essential requirements.
May I please, Your Lordship? Your Lordship, I've already stated in our affidavit, Your Lordship, a new source to supply water has already been identified. Work has already been done, Your Lordship.
That's 4 kilometers away.
Yes, that's a 4 kilometers. It's not simply not working.
Then what can we do, Mr. Yoban? They have
my lord,
it's not a question of inaction or they're deaf to your to your grievances.
My lord.
Where's the affidavit? What have you said?
The affidavit's filed on the.
Filed on 22nd March, Your Lordship.
See the next photos also.
Yes, sir.
Of these photos are there, my lord. This is very beautiful photos, but it's simply not working, my lord. They have done a good job. I'm not saying they have spent crores of money.
They've got treatment plant. They've made a treatment plant.
They have done everything.
Big pumps.
They have done everything, my lord.
Then
they have done everything. The water simply is not coming. And last week the engineer came. The engineer came and he's saying there is a problem. We will look into it.
What's the problem? No, see, it is not a dispute anymore between you and the villagers. Last time when you came, is that you're being deprived of water.
Yes.
Now they on affidavit they've shown the pump sets, the treatment plant, everything. I mean, what more do you want? What more can this court do?
My lord, may.
What can we do?
My lord, here, my lord. They have whatever they have done, my lord. But simply is that ground river still we are not getting water. We are aware of 100 household, my lord. We are 100 house.
You know how water stress all the villages are now, especially this climate change and all. Everything is.
My lord, that is there, my lord. But my lord, we are before, my lord, to help.
See, you are more fortunate. In other villages, they have to walk miles to get water. Here, they've made a treatment plant. They're pumping up the water to your village itself. So what can we do with the situation at this present stage?
My lord, what I would like to pray is, my lord, let
what
this.
Is your prayer now?
Let this.
The prayer is already been answered.
Let this matter be referred to a mediation, my lord. Let the villagers come, my lord, together. Because, my lord, at the end, because what happens is that, my lord, we are not
paying for the villagers. You are paying. They are the people who usurp all the water, correct? That's what you say. They're a bigger village last time.
So, my lord, what we are to pray, let there be a mediation, my lord. We'll sit down together because that is the only source of water which now, my lord has in the affidavit. Yes, my
your
lord.
Prayer. Yes. Now, what do you want? You wanted that the village get water.
Yes,
you
my lord.
That you shared a common source of water before with other villages.
Yes.
Then that source was disrupted.
Yes.
And then the pipes you had laid were also uprooted.
Destroyed. Yes.
And so you could not get water.
Yes.
And then when the other villages appeared, after the government said that since you're a bigger village, you've been, flexing your muscles and depriving the other villages of water. And so the government has made, the state has, from the same source, they're pumping up water to supply to your village. Now, what mediation do you want?
My lord,
are you getting water, Ms. Nongri?
They are getting ample water, my lord.
From the same source of own source,
from
not
the
from here.
From the same source.
See, they don't have from the own source. See?
They have connected illegally from the same source, my lord. Now, what we are saying is, my lord, let it be a mediation, my lord. Let all the village sit together. Let us try, my lord, at least once.
Resolved with the red code.
Exactly, that's why, my lord. Because, my lord, now today, my lord, if my lord, if my lord closes my door, my lord, not it's going to happen. It's not. We are going to be back to square one without water.
They have submitted that they've made provisions, and maybe there's some hiccups. So what will the court do?
4 kilometers from downhill, my lord, they are pumping.
4 kilometers they're pumping water.
1 week, my lord. 1 week they have been pumping. It's not even filling half a tanky, my lord. And we are
on what basis are you being submission?
My lord, under instruction, my lord, we are seeing every day, my lord.
You can see anything.
My lord, that is a fact. They can even the chief engineer, the engineer himself last week came and they says that there's a problem. There's a problem in the pumping.
I don't think you any more relieved what coming in a petition.
My lord, if kindly appreciate if my lord closes the door, my lord.
I'm not
now
closing the
door. That's why, my lord, let it give you some.
Approach the PHE again with the problems.
No, but PHE is very much aware. They have come. That's why the engineer has come to inspect also.
Then what more do you want?
No, my lord.
What can the court do? The court can only direct the state authorities to see that if there's some,
no,
there's some arbitrariness on their part, whereby they're depriving you something.
Yes.
The court examine that. There's been nothing of that sort. Government has come forward. They said we have done all this. Now your only grievance is that they're pumping 1 week and only half the tank is full.
Therefore,
can they be more?
Yes. Therefore, my lord.
You take instructions. You tell your people.
Therefore,
that courts are inclined. Listen, this matter up to 2 weeks for the orders. Yes.
No, therefore, my lord. Therefore, my lord. Let there be a mediation, my lord. Let both village come.
Why you want to drag them unnecessarily into another problem?
No, we're not dragging them, nation, because they're the one who's.
They're not concerned. They're saying fine. Whatever they from their own sources, they take water. They said we're happy.
No, it's not it's the same source, my lord. It's the same source. We're sharing. We have been sharing since time immemorial.
2 weeks is for the orders.
My lord.
You want to put anything, put an affidavit. Otherwise,
my lord,
the court not entertaining anymore.
My lord.
Enough. We've helped you enough.
Grateful, man. Obliged.
Lordship, in this case, everything has been done up. Only the deponent is on leave, so he'll be come back by Monday. So I need only 1 week's time to file my affidavit. Your Lordship.
Number 4. Two weeks for the time I sprayed.
12 also connected, Your Lordship.
12 also.
Allowed to respond to that affidavit.
13. 13.
May I please, Your Lordship? I am yet to file reply, Your Lordship. Because I have already forwarded the draft affidavit, but I am yet to receive from the.
You all have to
Your
take pause.
Lordship.
That means you're making misleading submission for the court. See the last order.
Yes, Your Lordship. But I have forwarded to the draft affidavit.
No. What? Who are they? The draft before the draft. Is a submission to make.
Because
officer
signators.
now, where is the officer situated?
Signatory is from the North Karo Hills, Your Lordship.
That's very far.
Yeah.
It takes us 5 hours to come here. Go and accept these. If you make a submission, that they will receive in the process of filing the affidavit. The process means filing is that the person's here and you're filing it. Not that you send it.
I am requesting them over phone to send me the draft so that they can come and.
This is not submission, please. Then say we can't file affidavit. We'll file it after 6 months.
No, Your Lordship. Annexes, everything is ready. Only they should come and sign.
What's the matter about?
Regarding pension, Your Lordship. Because he was appointed.
Pension?
Pension. He was appointed by the parent department.
Who's the person who's to file the affidavit?
Additional Deputy Commissioner from the North Karo Hills.
Very good. Yes, those submissions had been made and recorded by this court on 10/4/2024. That instructions had been received and the process of filing affidavit was on. Today, MSS Barashaji, Leonard GA, submits that the draft affidavit has been sent to North Karo Hills for obtaining what? For vetting.
Vetting,
For vetting is very good. For vetting by the Additional Deputy Commissioner. And thereafter, the affidavit will be filed when the concerned officer comes to Shillong to swear the affidavit. Stop. It is not understood under what circumstances these kind of submissions have been made initially as recorded in 10/4/2024. If the next record, as the matter concerns pension, if the said affidavit is not filed within 1 week from today,
2 weeks, Your Lordship.
1
Kindly.
week, the officer shall appear in person before this court. Enough of this pension matter. Yes. Yes, you file after also in 1 week. Yes.
14.
Too much silly. Then don't make the submissions. That's been a process of filing.
I'm sorry, Your Lordship.
No, nothing to be sorry about. It's all the,
Your Lordship, 2 weeks time I have given because they are not responding to my WhatsApp call also.
That's why let them come and appear.
Yes, Your Lordship. Much
Please, Lordship, Lordship, these people who have signed, Your Lordship, resigned, they have resigned from the association, and after the resignation, as per the article of the association, as a memorandum of association, we have appointed the new executive members. After new executive members have been appointed as per the rule of the association, we have filed an application for renewal, and then they said in the resignation that association is dissolved. As per the rule, Your Lordship, in the article of memorandum of association, it is page 34. It says that merely resigning of the member will not dissolve the association. So here is these people they have filed a complaint. They have resigned. The photocopy of the resign also we have, Lordship. If permit, I will file it additional.
No, are you a member of the old association?
Yes, I am the president. I am now re-elected. These people who
see the instructions last time.
Lordship.
This is signed by these people.
I place a letter dated, my lord, 6
With reference subject to read unassigned persons, right to inform you that based on information received, some unknown persons have filed for renewal of the all Garwis Association. That all the members of the Garwis Association have resigned from respective resignation except President. You're the President.
Lordship,
you kicked out all those other people.
No,
He's the
they
only
have
one,
with
my
their own will, with free will, they have resigned. I have all the resignation letter with me, Lordship. If Lordship kindly allow, I will file an affidavit.
So now the association is dissolved.
Association is not dissolved because the article. I just kindly have a look my page 33. 33. That is the memorandum of association. There is a dissolution, Lordship. Here, this is the procedure when the association can be dissolved. Lordship, I may read it, Lordship.
1 second, wait.
Yes.
So you did that. You want your own people only with you. No, you don't want anybody else from outside.
No, it's not like that, my lord, because these people, they have resigned. So we have accepted their resignation. After
Who accepted? You have?
Yes, we have.
Where's the minutes of the meeting then?
Minutes of the meeting, I have, Lordship. I have,
okay,
Lordship.
Fine. Where is the resolution?
May I just, because this is an official, Lordship, may I
See,
have?
the society shall be dissolved except by special resolution.
Yes.
Past special general meeting of members, over
Yes.
2/3 members.
Yes, may I just, yes. The society shall not be dissolved except by a special resolution passed by a special general meeting of the member by vote of 2/3 of the member present. D. Quorum at the meeting shall be as shown 2/3 of the member present in the said meeting. If no quorum is obtained, the proposal to dissolve the society shall be submitted to the further general meeting, which shall be held with 1 calendar month. The notice of the meeting shall be given to all the members of the society at least 14 days before the date of the meeting. The quorum for this
So the association, everyone's gone. Oh, you're the only member now.
The president.
No members at all anymore.
No, there are other members because we are the executive
members.
members.
Where's the meeting then electing these new executive members?
Yes,
for the
we have
association?
Lordship.
You have not annexed it either.
Before I have not annexed it because
Why?
Because this petition come because we are only for renewal. In the renewal, when they rejected, they have
So
not.
after writ petition was filed, then you made the resolution.
No. Before that only. Before that, see the Lordship, the meeting, the resignation take place on 18 February 2023. Thereafter on 24 April, February 2023.
How many members do you have in the association now?
Lordship.
How many members? Show you a list of
The
members.
executive members we have
all your entire membership of the association. I'm not talking about executive body. Executive body might be president, vice president, treasurer.
Yes,
so on and so forth.
that
now, who are members?
That Lordship I will place before. Yes.
Because you see, to constitute your
Yes.
executive body, there has to be an election from amongst the members. We elect Mr. A, B, so on and so forth. Then from there on, now what has happened here is that those members before, they've all resigned ever, they've written a complaint against you, saying that it stands dissolved. These are unknown persons under your leadership have come and said that they're the new executive body. Correct? That's what they're saying.
Yes, that is, yes.
That's what they are saying, right?
Yes, that is
so
their
that is
reason.
why the registrar of society is saying, wait, no, let us see. What is the problem?
Yes.
We can't register just away. And now you've come by writ petition to get a direction to force them to register your executive body, correct?
Yes.
You file additional affidavit.
Yes, Lordship. Whatever
supporting
document.
documents
Yes.
If you're the only member left, then...
No, not only because we are the executive office bearer, then we have other members also, Lordship.
Mr. Petitioner prays for and allowed 2 weeks' time to file and actually bring a record further materials in support of his case.
Yes, Lordship.
If you can't bring...
Lordship, I bow down.
You start a new association. Forget the old one.
Yes. Much less, Lordship.
One second.
Just wait.
My
lord,
you're for 1 to 7.
My lord, I have an objection, my lord. Here, my lord, here, the petitioner, my lord, have not made the correct party, my lord. Here, as per our copy, my lord. The corrected copy. We have already sent for instruction, my lord.
1 second. You are being 1 to 7, correct?
My lord, I am for 1 to 7.
Yes.
We have given us the corrected
What's your
copy.
objection?
My lord, they have already given us the corrected copy, it seems. They have not given us on the last occasion.
You are appearing for? 8, 9,
In the
and
main
10.
copy, you did not give us the corrected copy. Collector was missing.
You file affidavits? Yes, MS A. Pradhan has entered appearance today on behalf of respondents 8, 9, and 10. Such no further notice called for. You pray for, what about, you want to file affidavit?
My lord, we will be filing.
MS R. Kohli on behalf 1 to 7.
1 to 7.
A. Pradhan on behalf of 8 to 10. And C. Marbo on behalf of 11 pray for allowed. 2 weeks time to file affidavits. Yes, this thereafter.
16.
I'm appearing for 1 to 4, my lord, here. This also recruitment, selection of teachers, my lord. Dadingri. We will be filing our affidavit, my lord, here. Affidavit will be required.
Yes,
I'm entering appearance on behalf of respondent number 18.
number? 18. Only one. What about our ED card? Officer indicates
5
that
to 21 is private respondents.
respondents number 5 to 9, 11, then comma 12, 14, 16 to 20 have been received. Ini, yang respondent 19 to receive, and immediately 19 has not been received. What do you?
These are the selected people. This one also was there. This also was. Because I finished the affidavit, I saw the name. These are the same people only.
Top no?
This also.
Then what happened? It indicates that all the other respondents have been served except for respondents number 10, 13, 15, 19, and 21. Stop today, Mr. So-and-so sent a bill on behalf of someone 18. There's no appearance on behalf of the other respondents who have been served. And just after 3 weeks for affidavit and for service report the other respondents.
Which would like 17.
Correct, no?
On behalf of respondent number 6, I'm attending and appearance.
Very good. Mr. Vijurwa, yes, entered the pen on behalf of number 6. This is 6 is whom?
6 is the same.
This time, Lordship, to file my
He prays for the Lord.
petition.
1, 2, 3.
Yes, prays for allowed 3 weeks time to file affidavit. And he submits that on maintainability. 2 weeks then. Yes, 2 weeks.
18.
Lordship, we are seeking instructions, Lordship. We have already taken the steps. We are awaiting instructions. So, Lordship, we pray for 3 weeks' time.
Mr. Khwa prays for allowed for 2 weeks time to obtain instruction to file affidavit less thereafter and so on. So. Yes.
Your pleasure.
Hearing. Item 20.
Yes. The remnants of the day. Or the remains of the day, you know.
Because the issue is a little bit different here regarding the legal aids. See, if I give it 2 weeks time only, I'll just prepare my case and come back.
But it will be the same here.
Almost having good laugh.
But the judgment already passed is in anyway, but there is some...
Judgment's already been passed.
But
it affects you 90%.
Affect my 90%, but still there is a way to go.
10% also still left to struggle here.
To file an appeal. Still, that remedy is not obtained.
Though substantially the matter has been decided in the other second appeals, so Mr. M. Kurushi prays we allowed 1 week's time to
2 weeks,
2 weeks time to prepare the matter better.
Both the cases. If Lordship allow me to brief Your Lordship, the earlier STB case Your Lordship came for CAB, I believe. Recently, I got a judgment. The DB, if Lordship permits me. Much all right.
Yes, I got to Kiran Thapa.
Leaseholder association. Same matter, sir.
23.
Your Lordship, this
We have
matter.
sought for time this matter.
Yes, Your Lordship.
What to do? Last time, why none appeared?
I was there, Your Lordship, at the last
You were here?
occasion. Yes, Your Lordship.
Then why didn't you appear?
From the other side, they had mentioned, Your Lordship, on the other side.
How much? After 1 week?
Yes, Your
2
Lordship.
weeks, yes. On the parade of the council for the petitioners or the parties, this is a matter after 2 weeks, yes. 23 and
24.
24.
27.
Yes.
Lordship, here we are supposed to file a simplified calculation.
Yes. Where's the simplified calculation?
Lordship, we need some time, Lordship, here.
It's only with regard to
Only with regard to that, the amount which they have paid but delayed.
yes, delayed. Yes. Mr. MSP Varshaji prays for a lot further.
2 weeks.
2 weeks time to file simplified calculation.
Give us 3 weeks time now.
No, 2 weeks time.
Give us
Because it's at the verge of being disposed of.
Yes, at the verge of being disposed.
Yes.
28.
Tu bentar nak bahas ni, Arbitration.
Your Lordship, I pray that this matter may be passed over for the time being. Mr. H. Karwanlang is on legs in court number 1.
Only instructions whether he'll afford the salary to the petitioner. Correct?
Yes.
Yes, okay, call out.
Obliged, Your Lordship.
11:30, yeah.
32.
May it please Your Lordship. Lordship, the prayer in the instant writ petition is very limited. The petitioners herein had filed a complaint before the respondent number 6, that is the BDO of Silsila C&RD block, on 21st November 2022. The allegations made in the complaint were, firstly, with regard to misappropriation of funds.
By whom?
By the secretary of the VEC. Misappropriation of funds. And secondly, until August 2021, there was no direct payment system of the daily wages to the job card holders. So, till August 2021, the secretary used to take 50% of the wages from the job card holders, and if they would refuse to pay the 50% of the wages to the secretary, he would say that in the next work order or any work sanctioned to us, we will not include your names in the muster roll. This was brought to the notice of the BDO. Even after August 2021, when the daily wages were being directly paid in the accounts of the job card holders, the same threatening was there by the VEC secretary that I will not include your name in the future work orders if you don't pay me 50% of the wages that you have received. So he used to take in cash from them. Apart from that, the petitioner had also filed an RTI before the office of the respondent number 6.
Who's the petitioner?
The petitioner, my lord, they are the job card holders of
You didn't complain to anybody, you didn't file any criminal case, criminal complaint or something. This is amounts to extortion.
Yes, my lord, it amounts to extortion.
Then
So
did you file any complaint?
they filed this complaint to the BDO.
Yes.
To the BDO. And then prior to filing of the complaint, the petitioners also filed an RTI application through their engaged counsel seeking the details that from 2016, January 2016, this particular secretary had joined as the VEC secretary. He was elected. So from 2016 till the date of till 2022, what were the work orders which were issued in favor of Sobribari VEC? This is with regard to Sobribari. So they got the details of the work orders. Some work orders were provided, some work orders were not provided. As such, the petitioners approached they filed an appeal, the first appeal under RTI Act, and the same is still pending. The documents have not yet been received.
So you're seeking by this, what are you asking by this petition?
Our prayer, my lord, our prayer is only limited to the fact that the respondent number 6 should conduct a proper inquiry. In the affidavit in opposition filed by the state, it has been, my lord, there are two aspects in this matter. Even after the petitioners had filed the complaint before the respondent number 6 that there is misappropriation of funds by the VEC secretary, we had also prayed that...
Is the VEC secretary the same one continuing now?
Yes, my lord. Till now, it's the same person.
That is...
Respondent number 8.
8, okay.
Yes, respondent number 8, my lord.
Yes.
It was subsequently impleaded.
Yes.
So respondent number 8 is the secretary. And the other aspect is, in the matter, we had also prayed before the BDO that don't release any more funds until the inquiry is completed. But he has been continuously releasing funds with regard to the material component, and the total amount has come to, my lord, 35,06,110 rupees that has been disbursed. And amount has also been disbursed
Let's see your
during
first
the...
complaint.
My lord, the complaint is at page number 12, annexure 1. Yes, my lord, 22. After 22, reminders were sent. Reminders were sent on...
You mean to say that he didn't do anything? He didn't conduct even one single inquiry or
no
call
inquiry.
the secretary of the VEC or president to ask him whether, nothing?
No inquiry was done. Subsequently, the undersecretary to the CNRD department had issued letters. So finally, it is said by the respondents that inquiry was conducted on 4th April 2023, 14th April 2023.
Where is that?
It is in the affidavit in opposition filed by the respondent number 6.
So nothing wrong they found out?
My lord, this we have countered with regard to the inquiry. On 4th April, there was no inquiry conducted. On 13th April, my lord, we admit that an inquiry was conducted, but they did not come with the tools for the measurement whether the work has been done in its proper order or not. And the last one, the last date was 10th of May. My lord, if your lordship kindly takes page 11 of the affidavit in opposition filed by respondent number 6. There is one important part which I would like to point out, my lord.
One second.
My lord.
Number 8, who's appearing on number 8?
Mr. Hassan is appearing.
Yes, madam. 7 and 8.
President. The pleadings of the state and the private respondent is almost the same.
Did you take part in the inquiry proceedings?
My lord, that is what I want to show. My lord, no notice was issued. Only on 10th May, I was there in the inquiry. But on 10th of May, what had happened was, there was a scuffle between the private respondents, men, and the petitioners. And
So
subsequent to
means
that, we lodged an
towards them,
FIR.
Whatever they do, you never be satisfied.
No, my lord. There was a scuffle at the inspection spot. Inspection has not been carried out, my lord. Our only prayer is...
So you stopped this inspection from being done?
We did not, my lord.
Then who was beating up whom then?
The men of the president and secretary, they all out and there was a scuffle. And subsequently, the petitioners lodged an FIR before the Halidaganj police station. And it was registered as miss case number 171 of 2023. It has been placed on record by way of the rejoinder. The FIR was lodged by the petitioners. And the same is pending. Our only prayer is a proper inquiry should be held as to how much of the work has actually been done according to the work order. In fact, my lord, it is very surprising. I just went through the findings that has been given by the so-called inquiry officer. He says at
Where's the inquiry report?
page 11 of the affidavit in opposition filed by the respondent number 6. Now, my lord, if I may just take your lordship to the second paragraph on 14th April 2023. Lord, in the first line, he says inspection were done along with measurement of the project in the presence of VEC functionaries. Now, my lord, if we go to the third line, it says inspection had to be stopped owing to the absence of the VEC. Only the president was present, complainant and villagers was present. But this took place on 13th April. So, if the secretary is not there, proper measurements are not done. One place he is saying VEC functionary is not present. One place he is saying VEC functionaries.
1 second, wait.
President present.
See, it doesn't say that. It says that inspections were done along with measurements. On 4th of April, they conducted the first inquiry.
My lord, on 4th April, we have categorically denied.
They could not complete it, right? Then inspections were done along measurements of projects, functions, complainants, you were present. The inspections measurements could not be completed, especially with stop absence. That means might have left. Or the VEC president, complainant were present during the inspection that could not identify the projects. Fine, they were present on both occasions. Then 10th of May, inspection done around measurement of project, so while conduction and so you got to hear and the inquiry be complete difficulty. When you complete the 30 projects, so. Yes, what remains?
Yes, my lord. The next page, my lord, if your lordship kindly takes, page number 12. I'll take your lordship only to the remarks column.
We'll not go into facts.
My lord, not on facts. Just
the thing is that, see, you have made a complaint that one has been attended to by the respondents, and they found nothing wrong. And if you cannot seek to settle scores
one
by
thing, my
a
lord.
Petition, yes.
Just one thing, if I may show, my lord. Just one thing.
If I may, my
Okay,
lord.
okay, one thing. Let us show one thing. What is that?
My lord, page number 12 of the affidavit in opposition.
Yes. Yes.
My lord, once the work order is issued,
Yes.
it cannot be override. It has to be complied with. Now here it says, my lord, just one thing. It's a part of the inquiry report, my lord. The construction of road was done in part wise in 3 places in the VC, retaining wall constructed.
Where are you reading from?
My lord, if I may take your lordship to page number 12.
Yes, which part number 12?
My lord, the remarks column,
Yes.
the third one.
Yes.
Serial number 3 remarks. According to estimate, the length is 0.270 kilometers, but in work order it was mistaken and written as 0.311 kilometers. Yes. My lord, how can the work order be wrong and the work done be less? My lord, this is complete favoritism.
Yes, what do you have to say?
May it please your lordship.
Yes.
Lordship, on the points raised by the petitioner lordship, in the first instance, lordship, we have completed the inquiry. And by the term proper, I don't understand what they mean proper, lordship, because we have given our report also. Secondly, lordship, payment was made for work done, not in advance, lordship. And lordship, if they are making allegations about some 50% cut or something, lordship, right now, lordship, throughout India, VEC, the payment goes to DBT, lordship. That is direct benefit transfer, lordship. So that is not our purview, lordship. We have transferred the amount to be paid to the workers, the laborers, directly to their account. So that is one aspect that has been brought up, lordship. And thirdly, lordship, as we have given a report, lordship, they said they were never given notice. How were they present on all 3 dates, lordship? They themselves, they are coming with unclean hands, making allegations against respondent number 6. We have completed the job. So, lordship, they are trying to come into this honourable court through 226 when the same is not maintainable, lordship, because we have done our part from the government, lordship. So, our prayer is that it should be dismissed with cause.
Yes, Mr. Hassan. Why are you fighting with the petitioner then?
village, my lord. There's the same situation.
Always fighting.
There's a rival group always exists, my lord, in every village, my lord. So inquiry has been conducted. That's a fact.
Take down, yes.
Lord, just
Yes,
one
enough,
point.
enough. Please sit down. We'll hear the order.
My lord,
Please hear
just the
I'll-
denial on
enough.
the rejoin on the reply, my lord.
Yes, please sit down.
In the rejoinder, it is
Please sit down.
categorical.
Please sit down. I think it's enough. The only thing court's concerned if there's any violation of any national justice or something where you prayed. You haven't filed a complaint against that alleged extortion. Nothing is there. Yes, take down the writ petitioners are before this court with a prayer to direct the respondent number 6, who is the block development officer stroke program officer, former MREGS Cellcella, SELSELLA, CNRD block, former Cellcella, West Garo Hills District, Meghalaya, not release the pending funds of the Sobri Bari, SOBRI VEC, until the final disposal of a complaint dated 21/11/2022, and also for a direction to the respondents to initiate an inquiry against respondent number 6 with regard to the release of funds for the preceding years, for the years 2022 to 23. Stop. MSP Agarwal Leonard, counsel for the petitioner, has submitted that the writ petitioners, one petitioner or how many petitioners are here? The writ petitioners are job card holders within the said VEC, and that they are aggrieved with the actions of the respondents number 7 and 8 who have discriminated against them and even sought to extort the wages paid to the other job card holders. Stop. It has been further submitted that the manner of operation of the said VEC under the respondents 7 and 8 is irregular, especially with regard to the work that has been completed and the payments that have been released or advanced up through the respondent number 6. She further submits that though inquiries were held, the same were not proper, and as such she prays that a thorough inquiry be gone into with regard to the allegations against the respondents 7 and 8, more particularly. Stop. Next paragraph. MS NG Shilla Leonard, Senior Government Advocate, on behalf of the respondents number 1 to 6, has submitted that no case has been made out by the petitioner in view of the fact that no case that submits that on the complaint of the writ petitioners, inquiries had been conducted and reports were generated, a part of measurement of the works. She submits that, she submits that the writ petitioners had participated in the same, and as such at this stage cannot any longer harbor any grievance apart from their own, their own personal enmity which they might hold. Stop. It is further submitted that the wages of the job card holders is directly paid into the account, and if the petitioners have any complaints with regard to any extortion, they should have taken steps in accordance with law. He submits that there's not one FIR we filed.
FIR was only
Yes,
with regard to the scuffle.
Yes, she submits that with regard to state extortion, there's nothing in record to show that show that the petitioners had taken any steps before the police or other authorities. Next by Ms. S. Hassan on behalf of Respondents 7 and 8 submits that the writ petitioner having an inimical attitude towards the Respondents 7 and 8 for discharging the duties has come up with a frivolous writ petition. Just in order to harass you.
Yes, my lord.
No, you won't write that. It's a frivolous petition which has no basis. He further supports submissions made by the GA. Next paragraph. Heard the counsels for the parties stop. As noted earlier, the prayer is for directions for Contractor inquiry and for also to question the respondent number 6 as to the release of funds. This court from the to the said VAC. Stop. It is further noted that the entire writ petition is based on the perceived complaints with regard to improper execution of works. Stop. From the materials as placed, it is noted that it's noted them already. It's noted from the it's noted from materials placed. Works by the said VEC under the president and secretaryship of the respondents 7 and 8. After that, after the sentence, from the materials as placed, it is seen that pursuant to the complaints, a report dated 11/5/2023, signed by an inquiry officer appointed to conduct the same, has been filed. Stop approval of the same shows that on 3 dates, the inquiry proceedings had been conducted. And in spite of a heated argument, the same was completed, though with difficulty. From the inquiry report, it is observed that the projects. You do one thing. Inquiry report dated as was filed by the. Was submitted detailing the inquiry that had been gone into. The inquiry report, for the sake of convenience, is reproduced here and below. Next paragraph. From a perusal of the inquiry report, it is clearly seen that the complainants, job card holders, BEC functionaries, were all present. And also that the findings contained therein have not revealed any irregularities. Let's view the matter as the complaints of the writ have been answered. Stop. The writ petition, indeed being frivolous, is not entertained inasmuch as adequate opportunity had been granted to them at the time of the inquiry. Accordingly seems dismissed. Yes.
Much obliged, Lordship.
Item 33. 33.
Please, Lordship.
Yes, Mr. Arang.
The arguing counsel, Mr. Sheikh, is in court number 3, Lordship.
Who's there?
S.A. Sheikh is in court number 3, Lordship. Arguing counsel.
Doesn't matter, you start.
Okay, Lordship.
What's the matter about? Pension?
Pension matter, Lordship, is change of nominee, Lordship, in the pension paper order, Lordship. Some order.
Lordship, this is a covert case. Past.
How come you appear by magic suddenly?
I came from other court, Lordship.
Yes. I was quite startled because I was looking and I heard this different voice. Yes.
Here, Lordship, the petitioner is a retired government LP teacher, Lordship. He has retired on 38/6/2002, Lordship.
Yes.
Then, Lordship, then after the expiry of his first wife, Lordship, because his first wife died, and after the expiry of the first wife, Lordship, he contracted the second marriage, Lordship. The second marriage which he has contracted on
post-retirement?
Yes, Lordship. 22nd April 2020, Lordship.
He retired when?
2002, Lordship.
2002? So after 18 years,
after 18 years,
18 years after retirement, he contracted second marriage.
After the yes, Lordship. After the expiry of the first
Before
wife.
that,
The first wife expired, Lordship. Then, Lordship, he has sent a letter to the department seeking change of nomination in the pension paper, Lordship. Now, that letter, Lordship will find at page 15. The next page, Lordship, is the forwarding letter by the government, Lordship, subdivisional. I'll refer page 17, Lordship. This is the replica of my application, Lordship. This is letter dated 24 November 2021.
yes.
The subject is apply for changing of new nominee in PPO number so-and-so in place of his deceased wife. With reference to the subject cited above, I have the honor to furnish here with the original application for changing of new nominee, Srimati so-and-so in place of late so-and-so, deceased wife of Sri Jamshed Ali, retired teacher under Dadangiri subdivision, West Garo Hills. Therefore, I have the honor to inform you that his wife has expired on so-and-so, and he remarried so-and-so, and the nominee should be changed from the PPO number so-and-so in place of the deceased wife. This is for your information. And this letter was written by the subdivisional officer to the Accountant General, Lordship. Now, what is the response, Lordship, from the Accountant General? That is at page 18, Lordship.
Yes.
Now they have taken the plea that since I have contracted this second marriage prior to the amended rule, Lordship, and I have retired prior to the amended rule. The amended rule came into force on 1st July 2007, but I have retired prior to the amended
You retired 2002.
2. But
Okay,
the
now,
rule...
Now 2002, you retired, not amended rule, that's Rule 48.
Yes, 48, Lordship, yes.
Rule 40 was amended on?
2010, but it...
In 2010?
10. That is at page, Lordship, 4th November 2010, Lordship.
Okay.
So their only contention is that...
You're not covered by the amendment?
Yes, Lordship. Since my date of retirement is prior to the coming into force of the amended rules, that is why my case is not covered. Here, Lordship, it is not a case for pension, Lordship. Pension after my demise. After my demise, if she is entitled, that would be another cause of action, Lordship. Here I am with regard to change of nomination. Because tomorrow, if anything happens, Lordship, again unnecessary, she has to face all the troubles. That is why I...
Yeah, this covered case, what judgments then?
Yes, Lordship.
Of this court only?
My Lord I am relying 4 judgment, Lordship, here. There are 4 judgments.
Which paragraph? Para 8?
Lordship, the facts, Lordship, see the paragraph 2, Lordship, facts, Lordship. Facts is...
Yes.
Paragraph 2 is the facts.
Yes.
Set out so-and-so,
Yes.
husband of the pit working as teacher in so-and-so government LP school. He retired from service on 1st September 1984. After retirement, he married with the first wife, namely so-and-so, who expired on so-and-so. Thereafter, he got married with the petitioner on 2006, a copy of marriage certificate. So after his death, the petitioner applied for grant of family pension, which was declined by the respondent by letter dated so-and-so. Now, what is the observation, Lordship? Para 6, 7, and 8 is the quoted rule, Lordship. Then after that, 15, 16, and 17 is the observation, Lordship. And the Lordship, next judgment, Lordship.
1 second. There's on a different premise. It's regarding definition of family.
Lordship?
It's regarding definition of family.
Yes, Lordship.
That's all, because out here they said before his sons, after amendment includes a post-retirement spouse. Correct,
yes,
Mary? This judgment won't apply. Next
Lordship will then, Lordship, here, Lordship, page 9, Lordship, my Lordship has passed the judgment. At change of nomination, Lordship. Here also, here in this case, Lordship, page 9, Lordship.
Yeah.
Here in this case, during the lifetime of the husband, Lordship, he put up an application. And during the pendency of the application, Lordship, he died, Lordship. Then why file seeking change of nomination, Lordship? Here the private respondent also contested, Lordship.
Yes. This last one covers it, because why can you deny it? It's a question of change nomination. It's a question of what's the objection?
They have raised similar.
Before the authorities, you've given your marriage certificate, death certificate, everything. Then nothing is there.
It is reflected in the forwarding letter, Lordship, that which I have referred, Lordship, now.
Anything to see? We'll pass orders then.
Lordship, if it's a covered case, then...
Yes.
My Lord, in second judgment, my friend has appeared from the government.
No, that doesn't matter. Yes. Anything to say, Ms. Haromplang?
Para 6, Lordship, will be by affidavit.
It's an amendment of the state government.
Yes, Lordship.
So
it's a covered rule.
Yes.
It's a covered case.
Then we will pass orders. Yes.
34.
I just come back.
Much obliged, Lordship.
5 minutes, yes. Let's go.
May I please, Your Lordship? The conducting counsel as Islam, he is fall sick, my lord.
He fell sick?
Yes, my lord. He is from Guwahati. So he just informed me in the morning. So,
This is basically the appointment of
yes,
headmistress
my lord.
matter.
Appointment, the promotion matter, my lord.
It was just fixed
At
for
the fake end
instructions
of
by
her
the
service,
petitioner.
she was.
Persons adjourned due to the as the conducting counsels in this post just after 2 weeks.
2 weeks, my lord.
Obliged.
Hello.
36.
Aduh ni. Okay. Jadi okay. Isi itu. Yes.
May it please, Your Lordship. We've received the rejoinder affidavit, and
yes, we filed it on 29th.
29th?
29th of April.
1 second. You filed. When is the affidavit filed?
The
16/4.
Yes, we filed it on 29th/4. Lordship's last order was that it will be taken up for hearing today, and in the meantime we will file rejoinder. We filed it on 29th.
What did he say in affidavit?
Our basic contention in the
Ready
rejoinder.
with the matter today?
Yes, my lord.
Yes,
So-
1 second, 1 second.
So before I take your lordships to the rejoinder, my lord, I'll just
1 second, Mr. Doctor. Yes.
My lord, before I take your lordships to the rejoinder and the other contentions, my lord, the basic things that emerge out of the pleadings between the exchange between the parties, these are like that there was a tender notice on 4th of July 2023, and in response thereto 5 bids were received by the respondent MEPGCL. Now, out of the 5 bids, my lord, there was a requirement of deposit of earnest money to be, which was to be at the rate of 1% of the bid value. Now, from the disclosure that was made regarding deposit of earnest money, it appeared that 3 bids were identical. 3 bids of the private respondents herein, they were identical exactly on the same value, and those bids were submitted. There was a requirement that the bids will remain valid for a period of 90 days. That was a requirement on the tender conditions, and also the declaration made by the bidders. Now thereafter, the bids were processed, as the pleadings reveal that bids were processed, but nothing was done for a considerable period of time. During the period from October 2023 and onwards, I submitted representations before the MEPGCL asking that, as you say that the bids are at the, as it can be seen that the bids are at identical values, so what will become crucial in the process is the assessment on the responsiveness so far as the technical aspect of the matter is concerned. So kindly indicate on what basis the technical assessment has been done.
1 second.
So I request the respondents, the official respondents, to indicate as to on what basis the technical assessment responsiveness has been assessed. In reply, they say that we are looking into all the bidders have qualified on the technical side. But as far as the question of indicating the basis of technical assessment is concerned, we are looking into the matter and we will respond to you at a later point of time. That remains their constant response all throughout. Last representation was made by me in the month of February 2023, telling them that till now more than about half a year has elapsed. There has been no response to my query as to on what basis the technical responsiveness has been assessed. Kindly indicate that. Immediately thereafter, they issue the work order which goes in favor of the respondent number 9. Now this query of mine, that the bid assessment, bid responsiveness so far as the technical aspect of the matter is concerned, that remains unanswered. Even in the affidavit, there is no disclosure by the MEPGCL as to how the bid has been assessed on the aspect of technical assessment. Now, after the award of the contract, immediately, I come before your lordships. Now, in the affidavit, what comes out from the respondents, the official respondents, is that, my lord, out of the 5 bidders, barring me, all the 4 bidders had quoted exactly the same value, which happens to be the value of the tender. The value of the tender was 2 crores 87 lakhs 89,896, and the affidavit says that all the 4 bidders had quoted this rate, and my rate was 1 rupee 34 paisa above the rate of these 4 bidders. So the modalities that they adopt, they call all the 4 bidders for a price negotiation or sort of a post-bid negotiation. They appear before the MEPGCL on 7th of February, and thereafter 3 bidders out of those 4, they sign undertakings saying that we recall our bids or sort of we withdraw from the thing, and you make the award in favor of a particular respondent, which happens to be the respondent 9 in the case. Now, during the course of proceedings, my lord, there was an order from your lordships that as the private respondents were not responding to the notices, so we should take service by Dasti. Now, while taking the service through Dasti, it transpired that the respondents number 9, 10 and 11, they are all related to each other, staying under the same roof, at the same address. The respondent number 9 happens to be the son of respondent number 10, and the respondent number 11 happens to be the sister of the respondent number 10. So it was sort of a family affair from where the bids went. And the most striking feature of the case is that, my lord, in the tender conditions itself, it has been laid down that it's an item rate contract.
Meaning?
Meaning thereby that there will be several items for which they will have to quote rates. It's a construction of building, my lord, construction of a stadium.
Yes.
So therefore, there will be multiple categories of items that will be required to be supplied and used in the process of construction. So the requirement in the tender condition was that everyone was required to put rates of the particular items they will be applying for. And in case, it was also indicated that in case no rates are offered against the items, particular items, then it will be treated to be 0. Now, in such a scenario, your lordship, my submission is this. If it's an item rate contract, my lord, then no 2 contract can fetch exactly the same value unless and until there is a meeting of mind.
Yes.
And there are 4 of the tenderers who quote the exact...
All items.
All items fetching the same rate. Now, it is like, my lord, that there will be... I'm just amplifying this thing, my lord, by way of an example. As if, my lord, there will be...
Exact same rates.
Exactly same rates. Now, I can give an example, my lord. Supposing I am to construct a building, there will be requirement of rods, there will be requirement of cements, and so on and so forth. Now, for all these items, I am required to quote rates as per the tender conditions. Now, unless and until, my lord, there is a meeting of mind between the 4 of the tenderers, then how come the final figure of each of the tenders can come to the exactly the same value? And that to the estimated price of the tender. So
Yeah,
this
at quoted price of tender.
At the quoted price of the tender. and my price is only 1 rupee 34 paisa above the rates quoted by them, and which they, by showing that, my lord, that the difference of 1 rupee 34 paisa, they say that I am the L2 bidder, so I don't have any right to question the grant of award to the L1 bidder. Now, if your lordship visualizes this difference in the context of the value of the tender, my lord, we have calculated, my friend has calculated, it comes to the
how much?
0.000005%. Not even, that is the difference.
1 rupee 34 paisa.
1 rupee 34 paisa in the context of
And the total value of the contract?
2 crores 89,79,000. In a pragmatic, if your lordship looks at the matter in a pragmatic manner, my lord, my humble submission,
it R means not even RE 1.34.
There is nothing like hardly 1.34. Even a nut bolt, my lord, will not come at 1 rupee 34 paisa.
In the yes, okay.
And my lord, by showing me to be the L2 bidder, they say that public interest would suffer, or it will be against the interest of public if the L2 bid is to be considered. My lord, my humble and respectful submission before your lordship is that in the context of this value of the tender, my lord, practically it emerges that all of the 5 bidders had quoted the same value. Because this marginal...
Including you.
Including me. And therefore, my lord, if they were to go for a post-bid negotiation, my lord,
yes,
they were required by the rules of fairness and natural justice to call me also. And because lowering down the value by 1 rupee 34 paisa in the context of a bid which is 2 crores 89 lakhs, my lord, that's nothing certain big game. This is the aspect of the matter, my lord, based on which, my lord, my pleading in the petition goes that this selection of the respondent number 9 and the eventual allotment of the bid to the respondent number 9 is vitiated because of the arbitrariness. And there is also an element of favoritism. The second aspect of the matter is this, my lord.
Yes.
Now, if your lordship, now for the sake of argument, my lord, I am making this submission.
Yes.
Even if your lordship assumes that I am practically L2 bidder, for all practical purposes I am L2, then also, my lord, a question arises that whether the process of award of contract that the respondents have adopted, whether it is fair and justified. Because it's a process, my lord, where they call all the 4, the 3 sign some undertaking, my lord, they withdraw. And they say that no, allot the tender to this gentleman. Now the authority of the decision making, I mean the decision of the decision making authority is vested with the employer, not with the tender committee. Tender committee is only empowered to look into the responsiveness of the bid and the comparative assessment of the bids. Now, if the decision is to be taken as to whom shall the award go, it has to be a decision of the employer, not the my lord, the bidders who will decide amongst themselves that no, we will withdraw from ourselves and you award it to Mr. So-and-so. Apart from this, my lord, there is another aspect of the matter. The state of Meghalaya, my lord, has a set of rules indicating as to how a bid has to be withdrawn. In the particular website of the state, my lord, it's Meghalaya Tender Portal. It is named like that, my lord. In the rejoinder affidavit, my lord, we have indicated, my lord, there is a complete literature given by the Meghalaya government, my lord, as to how a bid process has to be withdrawn. It's an elaborate online process, my lord, through which, my lord, one has to log in into the system, select the particular bid he wants to withdraw, give his reasons for withdrawal, and thereafter, my lord, ultimately his withdrawal offer is accepted, and in the portal, my lord, it is registered that it has been withdrawn. Nothing of this sort has been applied by them. It's a sort of a family affair that they have made out, where 3 parties sitting over a cup of tea and one saying that the bid should go, the work should go to somebody.
But 2 other bidders withdrew.
Yes.
Out of 3, 2 withdrew.
Out of 4, my lord, 3 withdrew.
4.
Out of 4 who had quoted exactly same value, my lord, 3 withdrew. The third aspect of the matter is this, my lord. As far as the allotment of tender is concerned, my lord, there is a modality laid down by the government of India through a set of rules, my lord, which we identify as general financial rules. And in the framework of that rules, my lord, the Central Vigilance Commission, they have issued a certain set of guidelines. For it's kind of, it has been identified as there are three situations where the state may go for procuring services or procuring goods or procuring consultancy services. So for all these circumstances, my lord, the CVEC has framed three sets of guidelines. My lord, these are the volumes are as big as this. My lord, I have brought the printout for your lordship's reference also. I can give it to your lordship. So this is as big as this. And this lays down the categorical terms how the tender conditions has to be set, how the how the bids have to be evaluated, and how the responsiveness has to be assessed. In their entire of affidavit, my lord, there is no disclosure, although there is a specific contention raised by us that the financial aspect of the matter has not been, the basis of assessment of financial aspect has not been disclosed. In the affidavit, nothing has been disclosed. And particularly Rule 189 of the GFR, my lord, it says that if there is a technical bid, my lord, that has to be assessed by a third party. And even for the purpose of rejection and acceptance, the expert committee will have to record reasons. I'll just read out the provision. My lord, I'll give it to your lordship.
That's applicable to, because this is outside the purview. Is it a private? Is a contract not of the government? Is it of the government or?
My lord, MEPGCL
or MEPGCL is an agency that's just.
It's an agency, my lord.
Agency.
But the
project is
for construction of a stadium.
The funds come from?
Funds come from the MEPGCL and the state government. They are the funding source.
Okay.
Now, the rule says, my lord, how the evaluation of technical bids has to be done. Technical bids should be analyzed and evaluated by a consultancy evaluation committee constituted by the ministry or the department. The CSE shall record in detail the reasons for acceptance or rejection of the technical proposals analyzed and evaluated by it. I'll just pass on the book to your lordship, my lord. I have also quoted the provisions of the manual in the rejoinder itself. Still, my lord, I will supply that manual to your lordships. And your lordship will kindly look into. This is provision of General Financial Rules 189. Now, this is very crucial because, my lord, the purpose of the assessment is to find out the financial responsiveness through a technically competent committee. It is not just the employer or someone of his delegates sitting across a table and takes a decision, my lord. And the theme of the set of rules, my lord, is that, my lord, there has to be fairness and there has to be reasonableness in the process of selection and allotment, because it is.
That is the basis of the entire
case. Entire thing.
It's reasonableness and fairness.
So
we are there only. But the thing is that they are the owners of the work. They are liberty to the employers to do fair play, and the joints has to be there. But the fair play and the joints doesn't mean that it gives them license to arbitrate.
Exactly.
That's only
we're
looking within those on those
all
parameters.
That's all. Well, parameters are known to your lordship. I'll not.
The only thing is that we are looking is that we just have to the sequence and the action of the to show that it amounts to totally unreasonable and arbitrary and that kind of thing.
So therefore,
illegal. Yes.
Therefore, my lord, I said that even if your lordship takes a view that there has to be a fair play of joints, and there has to be some free will given to them. My lord, this is a situation, my lord, where the difference is only this. It reminds me of that famous Hindi film, my lord, where every time there used to be a tender and somebody would bid 1 rupee below the rate quoted by the competitor. So it is something coming out like this. A first case of my career, my lord, I should say, that where the difference is this insignificant numerical value. And by showing this insignificant numerical value, my lord, I am branded as the L2. So to say that since I am L2, I keep your mouth shut. You cannot come.
I mean, out. Yes, just shut it out.
Yes. So that, my lord, in my respectful submission, my lord, that will not stand the test of reasonableness and arbitrariness. And if you allow somebody to withdraw the bid, that has to, even by your, known set of procedures that the state of Meghalaya has been following, my lord, that has to be by following that procedure only. You in your portal you indicate that if somebody wants to withdraw the bid, then the bidder has to log into the system, submit the reasons for his withdrawal, and then only, my lord, that is withdrawal is accepted and done. That is not followed. And why I am citing this particular provision, as your lordship has raised the query to me that as to the applicability, my lord. If your lordship will look into the tender conditions, my lord, these are articulated in the same line as the set of rules.
Let's see the next condition.
Now, just for a purpose of reference, my lord, I am drawing your lordships to page 29 of the writ petition. As I first indicated that it will be an item rate contract, my lord, page 29 of the writ petition, my lord, clause 4, your lordship may see.
Financial bid.
Financial bid. The rates quoted shall be valid for items of work.
Yes.
It is an item rate contract. Items of work till the completion of the work for any increase or decrease in quantities as per final design and estimate. The rates should be quoted both in figures and words against each item of the schedule.
Yes.
All corrections should bear the dated initial of the tenderer. If there is any discrepancy between the rates quoted in figure and words, then the rates in words will be considered. Then down below in clause 9, that page 31, your lordship will find reiteration of the same things in the same vein.
Yes, page 31.
Page 31, clause 9. Contractor, am I with your lordship?
Yes,
Contractor must ensure to quote her rate. In addition to this, while selecting any of the cells, a warning appears that if any cell is left blank, the same shall be treated as zero. Because the cell is, my lord, in the context of the bids have to be submitted online, my lord. So there will be cells. Therefore, if any cell is left blank and no rate is quoted by the bidder, rate of such item shall be treated as zero. So it's an item rate contract. Now, in an item rate contract, you four are quoting exactly the same value, regardless of the items or the brands you use. Well, that is not possible unless there is a meeting of mind. And that indicates, my lord, my lord, that there is some connivance between the parties, which is apparent on record, my lord. This is
it's a collusive, collusive bid.
Yes, this is a collusive bid. A bid, it is simply, in a simpler term, my lord, I can say it's a case of bid rigging, where they have quoted the rates in such a manner, my lord, that it will be the identical price, and eventually one will emerge as the competitor.
But how did you quote 1 rupee 34 extra by accident?
I mean, discount or something from some source. But ultimately, eventually, it comes to a particular position where this is another indicator that even if the rates are, the items used are exactly same because in a construction of building, there will be rod, cement, everything, and the rates are almost known to each other. But still, there will be some big difference because of the fact that no two person can quote the exactly same rate. So as to reach the final figure, which is again the exactly tender value, as notified in the bid.
Next.
So then, and the other thing that your lordship may kindly come to page 38.
Yes.
Why I say that in essence, my lord, the tender conditions were drafted in the way it is required to be done in terms of GFR and the CVC manual.
That's what you want to see, yes.
Your lordship may kindly come to page 38. The second paragraph, we agree to keep the tender open for 90 days from the date of submission thereof and not to make any modifications in its terms and conditions.
Yes.
Now, this particular clause is a reflection of a condition which the CVC guidelines indicate in, well, I'll supply the book to you. In clause 5.6.1, if your lordship will have this 5.6.1, this is also indicative of the fact that it has to be a period of 90 days. Yes. Timely processing of tenders, my lord. Delays in finalizing procurement deprive the public of the intended benefits and results in loss of revenue and cost overrun. Currently, the ministry's departments are generally awarding the contracts in 90 days from the date of tender opening for which the ministries and departments are asking for a validity of offer of contracts for 90 days. So this is indicative of the fact that the framework given in the CBC guidelines, my lord, they were in application, and therefore the bidders also had given an undertaking that the bid validity will be for a period of 90 days. Well, there are, I have brought it for your lordship's use only, my lord. Well, Lord, I have quoted the provisions in extenso in the rejoinder, my lord, but for the purpose of, my lord, ready reference, my lord, the books, this book can be of help. So this is also so from this, my lord, it appears that there has to be a validity period which is 90 days, and that is why, my lord, they indicate in the undertaking that the bid will remain valid for 90 days. And as far as the, if your lordship will kindly skip over the page to page 78 in the manual, my lord, the clause 5.6.5 is of significance. Page 78.
Yes.
Cartel formation pool rates. It is possible that sometimes a group of bidders quote the same rate against a tender. Such a pool cartel formation is against the basic principle of competitive bidding and defeats the very purpose of an open and competitive tendering system. Such and similar tactics to avoid control true competition in a tender leading to appreciable adverse effect on competition have been declared as an offence under Competition Act as amended by so-and-so, so-and-so. Such practices should be severely discouraged with strong measures. In case of evidence of cartel formation, this is important. Detailed cost analysis may be done by associating experts if necessary. Besides, suitable administrative actions can be resorted to, such as rejecting the offers, reporting the matter to trade associations, the Competition Commission, etc., and requesting them inter alia to take suitable strong actions against such firms. New firms may also be, that is not relevant. So this also envisages us an action by the employer. If the employer comes to have some amount of doubt on the bidding that there has been a cartel formation. So this is also a requirement of the framework that the Central Vigilance Commission has notified for all to follow. Well, these things have been given a complete go-by in the process of award. So therefore, my lord, my humble and respectful submission before your lordship is that this hyper-technical classification of branding the petitioner as L2 bidder, that has to be ignored. And if that is ignored, my lord, it is more than apparent on record that a process has been adopted where I have been deprived by the respondent from a fair consideration of my bid. And that vitiates the tender process. So my humble and respectful submission with your lordship will be to interfere with the process, and the remedy may be to direct them to either go for retendering or to have a comparative assessment amongst all the parties based on the responsiveness on financial assessment. Because technical assessment. Because that technical assessment is very crucial because of the fact that all of them have quoted the same rate. And in the book that I have submitted to your lordship, my lord,
this one you take it back, yes.
Yes. This is the, my lord, this is the genus of it, my lord. This is the guiding set of rules under which, my lord, the manual has been prepared. So apart from 189, there are other rules, my lord. I have made a reference in the rejoinder. My lord, that your lordship will come across. Based on these rules, my lord, the guidelines have been framed by the CVC. So that's my submission in nutshell.
Authorities?
Lordship?
Authorities, you put in authorities in support of your case?
Authorities, my lord, they have submitted 18 authorities, my lord, to negate my case. And in 18 authorities, my lord, the common thread is that it is, as it has fallen from your lordship, the only aperture that it gives to judicial review is whether there is an arbitrariness, unreasonableness, violation of natural justice. Laws are, these judgments right from Ron R.D. Shetty, Ramanna Dayaram Shetty, my lord, these laws are known to your lordship. I need not supplant anything to your lordship. Only thing is that, my lord, there is a recent judgment which I found, my lord. Of course, my lord, I am having only one copy. I will supply it to your lordship. BSN Joshi, my lord. That is a case, my lord, where...
Give it a citation.
The 2011 6 SSC, my lord. I have given the list of books, my lord. 2006 11 SSC.
2006?
11 SSC, page 548. BSN Joshi and Sons, my lord. There only paragraph 6 is very very important, my lord, that I may just read out very slowly, where it has been recognized. Oh, book is there, my lord. Paragraph 66 at page 571, your lordship may kindly see. All the previous decisions have been referred to, and the expansive role of superior courts, my lord, in the words of Supreme Court, my lord, this is the phraseology used. Paragraph 65, we are not oblivious of the expansive role of the superior courts in judicial review. We are also not shutting our eyes towards the new principles of judicial review which are being developed. But the law as it stands now, having regard to the principles laid down in the aforementioned decisions, may be summarized as under. Well, then it is given in seriatim. I will draw your lordship's attention particularly to clause 6 at page 572. Well, this is another reason, another area, my lord, where judicial review is permitted. Clause 6, your lordship may see, the contractors cannot form a cartel if, despite the same, their bids are considered and they are given an offer to match with the rates quoted by the lowest tenderer, public interest would be given priority. So this aspect of cartelization and all, those have also been taken into account to hold that will also give the superior courts a right to exercise the power of judicial review. And in the facts of this case also, my lord, there the contractor had, as maybe perhaps as our instruction goes, my lord, perhaps the contractor has begun the work and he has done it maybe for some extent. In this case also, in BS and Joshi case also, my lord,
that's immaterial. If it's found to be illegal, yes, then that they suffer the loss.
Here also, my lord, the contractors had done something, my lord. The Honorable Supreme Court said nothing doing, you stop it, and the rest of the work will be done by the petitioner, which was the petitioner in this case, my lord. So from that perspective, my lord, it's a case where your lordship's discretion
can be examined, because the trend of the trend of law now is that, especially in this new India, that courts are sort of cautioned to interfere in commercial matters.
No, that
public interest. That's the only thing.
That, my lord, on that I'll make a submission, my lord. After my learned friend submits his case, yes, my lord, I'll make a submission on that, how it is distinguishable, yes, in the present facts and circumstances.
Yes, Mr. Pandey, how long will you take? 10 minutes.
10-15 minutes, my lord, will take. My lord, the issue which has been canvassed before your lordship is in respect of whether 4 out of 5 bidders who have submitted their bid having identical bids is a case where the extremely narrow jurisdiction of this honorable court as far as tender jurisdiction is concerned is invocable or not. Now, my lords, if a mere perusal of the tender notification itself indicates that why that particular number was given by 4 out of the 5 bidders. My lords, may just see the tender notification, detailed tender notification at page 26 of the writ petition.
Okay.
Page 26 of the writ petition. Because Bilal have to see whether the rates which have been quoted by these 4 individuals, why are these rates quoted, and whether there is, as my learned senior says, that there is any appreciable adverse impact on the competition made out in this particular case or not. So, my lords, at page 26 is a notice dated 4th July 2023 for construction of multi-purpose indoor stadium, and the value, my lords, notes is 2,87,89,896. This is the value, and thereafter, my lords, a detailed notice is on the subsequent page. And the subsequent page also in the second column, yes, prescribes for the estimate value of the project, which is exactly the same, that is 2,87,89,896. Willots may just see thereafter the terms and conditions of the tender. And straight away, Willots, at page 29, which is the financial bid.
Yes.
Willots may see the Roman 3 in this. It says that tenders quoting below the estimated costs of the work will not be accepted. So you can quote above the estimated amount, but you cannot quote below it. And thereafter, just one more clause, my lords may see at page 30, which is also part of the same document, last, that is Roman 23.
Yes.
The department is not bound to accept the lowest tender or any tender and may reject any or all tenders without assigning any reason whatsoever and reserves the right to accept, reject the tenders.
That's there everywhere.
That's there. Just that is a part of the document itself, just to notify the bidders. Now thereafter, my lords may see my affidavit in response, which details the amounts quoted by these 4 individuals.
Yes.
My lords may directly see at page 41, which is annexure R1.
Forty-one,
my lords.
page 41.
Page 41.
Okay. Next R1, R2.
Yes, my lords. This is part of the minutes of the meeting, but my lords may just note that it says that the second paragraph, the chairman highlighted the matter related to meetings held earlier for a decision to select the successful bidder, since all 4 bidders, i.e. L1 bidders, are qualified and quoted at par in the price bid as indicated below. The names of these individuals are quoted, and the value, my lords may note, because the value is 2 crores 87 lakhs 89,896, which is the estimated value. So they have quoted the base value of the project, and there is no assumption, there is no possibility of any adverse impact on the competition being happening when all the bidders are quoting the base value.
Only one thing, then why didn't you call and negotiate also? It's only 1 rupee. If it's like a minuscule kind of a situation. Now it always demands that if you call the others, like usually all the bidders are called.
Because firstly, the good or bad, they are not the lowest bidder. So these bidders who were today, today the learned senior says that they are somehow connected with each other. There is no averment as such in the affidavit.
We filed an affidavit on that.
But be that as it may, whatever it may be, all the L1 bidders were called because the conflict as such, we as a public entity are interested in getting the lowest bid for our project. And these individuals...
But it is strange that only from one family, there's only one outsider and one family, the other. Where are the other bidders? There were no other bidders at all. It wasn't a closed tender, was it?
No, it was not a closed tender. It is quite, but the fact is,
because we've seen many cases, Mr. Pandey. It's very strange.
It's strange, my lord. But the thing is,
yes.
here
you have to explain the strangeness, and make it unstrange. It be as if it's run of the mill kind of a tender situation.
Because it is even more stranger that his bid is only rupees 1.34.
All these things, it's like a really strange kind of situation.
Right. It may have been that all the bidders are for buying for the contract, they are bidding for the lowest amount possible. And in that process, the petitioner has missed out by rupees 1.34 paise, whatever it is comes down to be. But the fact is the conflict as such for the department or for the corporation here lied for the identical bids. The identical bids of these 4 bidders. And for that purpose, as the tender notification itself, my lords, provides that I could have picked any one of them. But still, in the interest of natural justice, all were called. And thereafter, they came and said that we don't want to press with our bid. You can go ahead and pick one of them. And in that process, one of them has been picked.
It became a 2-horse race.
Huh?
Then it became, anyway,
so
okay.
one of them has been picked.
Sorry.
So that is the situation here, And as far as cartelization is concerned, my lords, cartelization has to happen, or bid rigging has to happen for certain benefit. Here, what benefit can anyone achieve by quoting the minimum amount? So that aspect has to be taken. What is the adverse impact on the competition if everybody is going on the lowest amount possible? There is no impact on the competition, and there is no reason, even if my
so that means he can't go to competition commission. Huh?
it is for him to decide that, but I don't think so.
Anyway.
Even this is a fit case for a competition commission.
Yes.
So that is the situation here, my lords. And in this regard, my lords may just see the counter affidavit which we have filed. Here, my lords may note also page 45 of the, because I'll just read page 41. Page 41 first, I have already read second paragraph. Thereafter, the third paragraph, my lords may just take notice of that also. The chairman, after scrutiny of all the MOMs, felt the process of allotment of the work had taken a long time, of which further delay will bring a great loss to the corporation as well as government in implementing the projects in the state and the beneficiaries of the state as a whole. After a threadbare discussion, the members agreed for expediting the process of allowing the L1 bidders to discuss and come to a mutual understanding among themselves to allow one bidder to execute the above mentioned work. As agreed by the tender committee members, the above said bidders had come into a resolution and agreed that the work should be given to bidder Shri Taveen Warjiri, who is respondent number 9, as a successful bidder. As such, an undertaking duly signed by other 3 qualified bidders' representatives has been done for authentication of the agreement for the next due course of action. The meeting has ended with a vote of thanks. And will also subsequently, at page 45, is the undertaking. This has reference to the meeting dated 7th February 2024 with members of the tender committee for construction of multi-purpose indoor stadium at Nongtroi village. Subsequent to the discussion in the meeting, we understand unanimously agreed in the interest of the state the work for construction of multi-purpose indoor stadium village may be allotted to Mr. Taibin Warjiri, and all these individuals have signed. Now, in this sort of a situation, all these 3 individuals, there could have been a possibility that these 3 individuals, having quoted the lowest bid, come to your lordship and says that yes, have the identical bids, we were denied an opportunity to get the tender work awarded to us. They are not even the lowest bidder, and
that is why you don't have to lift the veil, just lift it a peak behind the veil also.
Right.
Because why no objections were there? Because they had cartelized the whole thing to belong to the same family, notwithstanding the amount quoted.
Milord, just consider this situation.
The only that troubles the court is that the difference is so marginal.
Right.
And then
Milord, even a single paisa difference would have made that distinction. But still, what is the benefit that these 3 individuals are getting from quoting an identical bid when you are quoting the estimate value? The estimate value is being quoted. Nobody would gain anything from cartelization. That has to be, Milords, in my humble submission, taken into consideration. Milords, we have quoted the judgments on this issue. Milords is very well aware of all these judgments, but a few paragraphs I may just bring to the notice of this court.
Yes.
Milords, at page 5
of your affidavit.
Of my affidavit, Milords. Of page 5 of my affidavit, and Milords may just see State of Punjab versus Meherdeen, which is a 2002 judgment, is quoted. Only the bold portion I may read, Milords.
Yes.
This being a settled law that the highest bidder has even the highest bidder has no vested right to have the auction concluded in his favor, and in the given circumstances under the limited scope of judicial review under Article 226 of the Constitution, the High Court was not supposed to interfere in the opinion of the executive who were dealing on the subject unless the decision is totally arbitrary or unreasonable and it was not open for the High Court to sit like a court of appeal over the decision of the competent authority, and particularly in matters where the authority competent of floating the tender is the best judge of its requirements. Therefore, the interference otherwise has to be very minimal. My lords, in the similar vein, judgment of Honorable Supreme Court of 2023 in Tata Motors is quoted.
That's what schools say. The trend of the law now is like that.
Yes,
that, in commercial matters, you.
Yes,
so
the scope is very narrow, my lords. All these paragraphs, my lords, I may not take your lordship to only a certain. At page 22, my lords, may I just read the quoted portion of a judgment of National High Speed Railway Corporation versus Monte Carlo, which is again a 2022 judgment. However, the ground reality today is that almost no tender remains unchallenged. Unsuccessful parties or parties not even participating in the tender seek to invoke the jurisdiction of the High Court under Article 226. And my lords, then thereafter, the quoted portion, the highlighted part, the purpose is to check whether the choice of the decision is made lawfully and not to check whether the choice of the decision is sound. So here, the process has been followed and we have picked the lowest bidder, and that, my lords, has to be taken into consideration. And my lords, similarly, at page 25, the judgment of UFlex is quoted. Page 25, my lords, para 42. I am again reading the highlighted part only. For every succeeding party who gets a tender, there may be a couple or more parties who are not awarded the tender, as there can be only one L1. The question is, should the judicial process be resorted for downplaying the freedom which a tendering party has merely because it is a state or a public authority, making the said process even more cumbersome? And my lords, thereafter it says the objective is not to make the court an appellate authority for scrutinizing as to whom the tender should be awarded. Economics must be permitted to play its role, for which the tendering authorities knows the best as to what is suited in terms of technology and price for them. My lords, it then says it does appear that it is that in a competitive market they have not been so successful as they would like to be, merely because a company is more efficient, obtains better technologies, makes more competitive bids, and thus succeeds more cannot be a factor to deprive that company of commercial success on that pretext. It does not appear to us that this is what is happening, that the two original petitioners are endeavoring to continuously create impediments in the way of succeeding party merely because they themselves had not so succeeded. So, my lords, thereafter it goes on, but this aspect has to be taken into consideration. Other judgments are also, my lord, quoted. So, our submission is that being the lowest bidder, these individuals were called for a meeting and they themselves decided that only one of them would be pressing for their bid.
Now, what about the questions raised by the senior counsel with regard to the manner of withdrawal of bids? Is that is that mandatory? That should be followed as given in the portal of the government of Meghalaya?
Well, that as far as withdrawal of bids is concerned, here the situation is not technically of any bidder withdrawing a.
Yeah, that's because you see that is what Mr. Pani that it now leans towards cartelization in a sense that that all these bidders have come same amount, they've got together around the table, and just for say okay fine you do it. It's not a withdrawal also.
Well,
it is a sort of what do you call it, understanding.
Billots, I cannot really
And so
comment
understanding
upon as
amounts to, like whether, this cartelization or one point you have correct is that fine. Is not a question of any financial, benefit being derived by cartelization because they quoted at the minimum rate.
Minimum rate.
That's all. And doesn't mean that it quoted some rate which is,
Yes,
bit
yes.
higher and they all, they withdrew.
Yes.
That is okay, fine. But the only thing with the manner in which it had been, the whole process had been gone into, that's the only thing. And whether, that it allows, because is there any condition, I don't think there'll be in a general, there's a general, do you have another general form of contracts whereby they prohibit cartelization like they have in, like Assam Rifles and all they have, suppose, suppose husband and wife bid, right?
Yes, yes,
The
yes,
rates
yes,
are
yes.
little marginal and all, that kind of thing, because you know what the bids are, like you already have knowledge about what the other party is bidding, and so that
Right,
kind of
right.
thing. Though that comes with cartelization. Of course, that'll go for the competent commission.
Yes.
There's been some cases here also, but
Yes,
that's the
ma'am.
thing.
But that is not per se, Milods, in the, I couldn't find
Withdrawal with what is the purpose of withdrawal and whether
Because-
this is permissible. To
even-
negotiate, I can understand negotiating on the amount with the employer,
Right.
but negotiating among yourselves as to who's to get the contract,
Because
that's the only thing.
Yeah, I understand, Milods.
Yes.
Had it been a case, had it
Okay,
been,
negotiation, fine. You called them.
Yes.
Like, you called them, fine.
Just-
And then, like, okay, you settle, right? Can you match
And
his rate? It's just like, can you match his rate? Was that Swiss? Yeah.
So, Bilods, in this situation, had all the bidders who had come for this meeting had decided that they are not going to withdraw or they are going to go press for their individual bids, then even then MECL as the PGCL as the employer would have the authority to pick one of them.
Whatever, but then that's page 45, that is what, seals the deal in the sense that they've decided, they've sat and said that let him get the contract.
In this situation,
That means they are the people deciding who should get amongst them, not
they are
the
not,
employer.
basically they are not inclined. As an employer, I cannot give a bid to a bidder who's not inclined with the contract.
No, it's not that. You're the employer, you own the work.
Right.
It's entirely your discretion, especially now, so it's like that anyway.
So we have followed we are following the people who are quoting the lowest bids, and that is as far as the corporation is concerned. And if we could have given to any one of them.
Notwithstanding the fact that they're all coming from the same family, staying under one roof.
Because we are not aware
Have
about.
have you made any counter averments to that? No.
There are no specific averments in the affidavit per se that these individuals are related.
No,
Secondly,
it is there. It is
just a moment, sir. Secondly, the aspect whether they are related or there is a cartelization, it's a very complicated question of fact that we are not aware of, and as corporation we cannot really make any comment about whether there was any cartelization.
You know that other organizations, they have this mechanism.
Yes,
You're supposed to detect it in the process.
Yes,
So even when they came for negotiations,
But
that they are related or then at that point of time they can put an objection.
That
and
is there.
it
That is there. That is
Yes.
there. That is there.
That
But
is a
this
mechanism which prevents
this
cartelization.
in my humble case,
as per the directions of this manual for.
yes, I'll just refer to the manual also. But in this case, there is no cartelization. There is no cartelization because an estimated value is being prescribed. Everybody, he could also have.
To understand this code, that means this person is the only bidder, and the others all shadow bidders.
Could have been. Could
It points to that. It means only one bidder.
without
That make a better case for him. He's one bidder. If he had come here, but no one's appearing, he's a bidder. Other shadow bidders.
Even if I accept that they are shadow bidders.
Yes.
But the situation is that is not creating any difference in this situation.
Yes, it doesn't get a difference, but
not making any difference.
Well, it points to that. Just an observation.
Yes, Milot.
It points to that. That he's the main guy.
I follow that.
Yes.
Milot, and as far as the reference to the GFR, although it's not directly applicable in this particular case, Milot, but even if we go by the comments of the CVC in respect of cartelization, if I can place that, because that, Milot, again is something which is which is beyond the remit of a writ jurisdiction, because if there is anything, I'll just place that at page 16 of their rejoinder affidavit. It says that it is possible that sometimes.
Rejoinder.
Yes, my lord. Page 16, my lord, sir. I am going by the quoted part because.
Yes.
Yes, my lord. It is. This is 5.6.5
yes. Pool
cartel
rates.
formation pool rates. It is possible that sometimes a group of bidders quote the same rate against a tender. Such pool cartel formation is against the basic principle of competitive bidding and defeats the very purpose of an open and competitive tendering system. Such and similar tactics to avoid control of true competition in a tender leading to, now my lords, this is very important, appreciable adverse effect on competition. So that has to be there. If the purpose of certain bidding or collusion has to lead to something, that appreciable adverse effect would not lie where everybody is quoting on the base value.
That's the only thing that's in your favor, Mr. Pal. That's all.
That is all.
That's it.
That's it.
Yes. Anything to add?
Well, I'll just take a cue from my learned friend's submission, my lord. The citations that he has referred to. First citation that my learned friend has referred to, that is at page well, the principles that are governing the field, my lord, these are all known, my lord. From facts of the case, from fact to fact, my lord, there has been some modulations here and there, but the basic parameters on which, my lord, the judicial review is invoked, my lord, these are common to all. Page 42 he has referred to, page 22 of his affidavit he has referred to, my lord. The highlighted part, the purpose is to check whether the choice of decision is made lawfully, page 22. The purpose is to check whether the choice of decision is made lawfully and not to check whether the choice of decision is sound. My case is on the first part of the sentence.
It's unlawful.
Yes, that is it. And that is why, my lord, this judicial review will lie. And the second decision that my learned friend has referred at page 25, my lord, the second highlighted part, page 25.
Yes.
The objective is not to make the court an appellate authority for scrutinizing as to whom the tender should be awarded. Certainly not, my lord. Economics must be permitted to play its role, for which tendering authority knows best as to what is suited in terms of technology and price for them. So it is not the price alone, it is also the technology. And this aspect of the matter is taken care of while...
Where is it from? Sorry.
Page 25, my lord, the second highlighted part.
Yes.
The second highlighted part, the objective is not to make the court an appellate authority for scrutinizing as to whom the tender should be awarded.
Yes.
Economics must be permitted to play its role, for which the tendering authority knows best as to who is suited in terms of technology and price. Now, all along the emphasis is on the final price that is quoted by the bidders. What about the technology? That is something which will come into play when the technical assessment of the, assessment.
That he made the point that there was no.
So that is silent, my lord. In this case, my lord, that is silent. And as your lordship has also pointed out, if your lordship will kindly see the page 44 of their rejoinder, the last page.
Oh, you're 44.
Of their affidavit, my lord. Sorry, my lord, page 41. Page 41 of their annexure R1.
Yes.
The last paragraph, as agreed by the tender committee members, the above said bidders had come to a resolution and agreed that work should be given to bidder Sri Tabin Varziri. Now, is this, my humble question to myself, my lord, is this a procedure known to law as to how the tender has to be awarded? And significantly, my lord, he has submitted that the aspect of, I am not saying it's a cartelization, my lord. I am saying that it's a rigging, the bid is rigged. As your lordship has rightly pointed out, my lord, he is the bidder, actual bidder. The others are shadow bidders. And kindly see the signatures at the undertaking. Only one person signing for all, except the respondent number, except this Mostufar Kharkongar. Respondent number 11 is Colinstar Sokmi. He signs for himself. Respondent number 10 is a farm owned by his sister, and the same person also signs for himself.
This is interesting.
And the notices are also received like that. And my learned friend says that there is no specific government. I'll just point out the specific government in this case, my lord. If your lordship will take up my additional affidavit, which I had filed on 8th of March 2024, there your lordship will find, sorry, my lord, this is affidavit dated, this is affidavit.
19.3.
Yes. In that affidavit, my lord, paragraph 2, by an order dated 13th, may I just read that, my lord? By an order dated 13th March 2024, has your lordship got it?
Yes.
By an order dated 13th March 2024, this Honorable Court directed the petitioner to serve notices upon the private respondents number so-and-so, through Dasti. It is pertinent to mention herein that Taibin Varjiri, respondent number 9, is the son of Colinstar Sokmi, respondent number 11. It is also mentioned that Srimati Connie F. Sokmi, respondent number 10, and Colinstar Sokmi are related as brother and sister. However, in pursuance of the, my lord, that is how notice is served. And this same fact, my lord, I have also repeated in the rejoinder. I will just point out that from my rejoinder, my lord. In my rejoinder also, my lord, I have highlighted this. I have repeated this fact. So it goes, my lord, on record that there has been this, meeting of minds through which, my lord, the, there have been this meeting of minds. So eventually they wanted the respondent number 9 to emerge out as the successful bidder. That's why the shadow bidding. And that's why, my lord, ultimately they come to a table of compromise and withdraw their bids.
That goes against your case is that, they're quoted at the minimum price. That's the only thing. That there's no undue adverse kind of,
My lord, I am not saying that.
I understand.
So far as,
notwithstanding the other, points that you've raised, that's it.
Otherwise, my lord, if you, my lord, this is, as my learned friend has also said.
Like this court is saying, it's a very strange, curious case.
Very strange. My lord, I have also said so, my lord. In my 30 years of practice, my lord, this is the first case I have got where.
And even in the few years had as a judge also, as a lawyer also, it was the first very curious kind of case. You've seen catalyzation, where their bids and with the financial bids announced to each other, like how much,
Right.
That does happen. It does happen, but then they are separate bidders, but of course the rates are,
Higher.
Yeah, how much higher, So those kind of things.
Because if all the bidders combine and they go for a higher bid, then the corporation or the government is bound to suffer because all the bidders combine.
That is what, yes.
Yes.
Anyway, okay. No, reserve. Reserve. Okay. I thought she said it better reserve the judgment.
Might be she says that it could be a long one. With so many citations coming in.
Yes, heard counsel of the parties, arguments concluded, judgment reserved for the parties.
Obviously.
I was thinking of anyway. You take this back. It's your book.
Well, this manual, your lordship may keep, my lord.
Yes, thank you. Yes. Yes, Mr. Haruna.
Yes, Lordship. Lordship, on the last day, your Lordship was pleased to direct me to get instructions with regards to the payment. Lordship, I received instructions and the department is willing to pay for the period, Lordship.
Give me something in writing.
Lordship.
You have in your phone.
Lordship, I'm very sorry. Lordship, I can just.
You have instructions, written instructions.
Lordship.
Then you should produce them. Then we can close the matter and give Mr. Nyota some relief.
Lordship. I say we can just get 2 minutes. I just print it out.
Yes. We will take up the other matter.
Supplementary 1, item number 1.
Lordship, I'm being led by my senior, Lordship.
Where's more concerned about who's your respondent?
Lordship,
Council.
respondent is the DCM of
Is the
Nobosapa.
council?
No, not district council. Nobosapa. Because the CM has issued the auction notice, impugned auction notice.
No, but the thing is that in markets they have to go. They have to be. There's no approval of the
Lordship,
auction
it's
by
there,
the
it's there.
council.
It's there, Lordship. I'll come to that. Lordship, we'll take up the matter now.
Take it up. Yes, argue over the matter. There's no difference. Yes.
Please, Lordship.
Here's
Lordship,
the
may I
fact.
kindly come to straight away to the annexure, Lordship. Annexure 1, page 12. Lordship, this is the
1A.
Lordship.
Annexure?
Annexure 1, page 12.
Okay.
This is the auction
One
notice.
second.
Lordship, this auction notice was issued by the.
Okay. Yes.
Lordship, this auction notice was issued by the Umdolan Market Management Committee, which is a management under the Control Act, Lordship. Now they have issued a public notice calling for auctioning of the Umdolan market on 2nd April 2024. Now I've
28 March or 2nd April?
This is the notice is dated 28 March. Now the auction is supposed to be held on 2nd April.
Okay.
Now I participated in this auction notice. Now I was issued a permission license at page 15. The
Okay.
petitioner.
Yes.
So this is my license permission to operate the market, Umdolan market, till 31st March 2025.
31st March. Okay. Yes.
2025.
From 8 April.
From 8 April.
Yes.
Lordship, since then I have been collecting
Started
the
operations.
market tolls in the market.
What happened?
Now, surprisingly, Lordship, at page 20, Lordship. Now, Lordship, Lordship, kindly come again to annexure 12. Now, this auction was with annexure page 12, Lordship, page 12.
Yes.
The auction notice in which I was declared successful bidder, this auction notice was with the permission from the district council.
Yes.
It's in the first para of the auction
Okay,
notice.
22nd March. Yes.
Yes, Lordship. So now, Lordship, the impugned auction notice has been issued by the CM of Nobosapa at page 20. Page 20.
Where's the Khasi copy?
Khasi copy will be the last page, 22nd.
Okay, says that, no? The same market.
Same market, Umdolan market. And
You ever been to this market?
no, Raj, I've never got
I've
the
been to
opportunity
this
to.
market. I was stuck in this area due to landslides many years ago. I spent 4 days in this area. We couldn't get back to Shillong also.
Achha.
That time there was no mobile. Forget mobile, there's no connectivity. Yes.
So, Lordship.
That's why when you said Umdolan market, I know because we had this is the only market that was there. Yes.
Lordship, this impugned shockers or the auction notice is illegal, it's invalid, Lordship.
Yes. How can he?
And moreover, the market is run by the management, and this is
And
not
this- and
this
this
is
is
not
a
a market
this is
falling under the jurisdiction of this EM, Lordship.
No,
It's a
no
private
management
market.
is made under the management of this is yes.
Establishment management control of market.
And does he hold the office in the management committee of the market? This aim.
Pardon, Your Lordship?
Does he hold any office? Is he the secretary or something, or the managing committee?
The same, Lordship?
Yes.
No, Lordship, because this is a
Market's
private
owned
market.
by whom? It's a private market.
This is a
correct?
private market, owned by the Palayar clan, Lordship.
Okay. Take down, heard Mr. Eman Nongpur. Or should record Dr. Mozika's name. Okay, heard Mr. Eman Nongpur in the counsel for the petitioner. Stop. Issue notice. Issue notice. This is Southwest Kasi Hills. Issue notice returnable in 3 weeks.
3 weeks, Lordship.
Yes. Steps to be taken as AD within 3 days. Yes. Stop. The writ petitioner was a successful bidder to operate and manage, to operate and collect tolls. Collect tolls, right?
Market tolls.
To collect market tolls of Umdolun market, which was settled pursuant to a notice, auction notice dated 28 March 2024, which had been floated by the Umdolun Market Management Committee. Stop. Thereafter, it appears an agreement was also
License to collect toll was
license, a permission stroke license to collect was issued to the writ petitioner on 2/4/2024, and it is submitted that they have submitted that the writ petitioner started managing the said market, started collecting market, toll said market. Stop. The grievance, next paragraph, grievance, however, is that the respondent number one, that is the aim of Nobo Sopo, invite the impugned auction notice dated 25th April 2024 has called for fresh bids for the same market, which has already been settled with the writ petitioner. The writ counsel, Mr. Imanpur, submits that firstly, the same is without any authority, inasmuch as the market, the private market, under the control of the Palayar clan, owned by Palayar clan, and under the management of the, what's it called? The
Umdolun Market Management Committee.
Umdolun Market Management Committee. And secondly, the notice is per se illegal, as the market has already been settled with the writ petitioner. He therefore prays for some interim protection at this stage. See, one thing about markets, suppose there's any dispute regarding a market, you have a forum of appeal.
Lordship, that is one of the grounds that are taken by us. If at all the same is aggrieved by the notice, by the settlement.
For you also, it cuts both ways. Even for you also, if you agree with any notice challenging your, or that you should have gone to the district council and file a complaint against the auction notice and for setting it aside. But since it's urgent, since you said it's very urgent, so that's why court's taken it up.
Lordship, the impugned auction notice was issued on 1st. The auction is supposed to be held tomorrow, just 2 days.
That is
the illegality.
That is why the court's taking it up. It was issued on 1st, and the
auction to be held tomorrow, Lordship, up to 2 days.
Notice 25th April auction notice.
No, the impugned notice, Lordship. The impugned auction notice.
Yes. Is dated 25th April, you're saying?
April.
Then? It's not yesterday and tomorrow.
But Lordship, since it was already settled.
Yes, I took actually. Yes, the market. The print so small, you know. Yes.
It'll be in the first part of the.
Yes, no 385, yes.
Twenty 21 out.
No, where's the another one? Wait. I'll just be. Yes, Tom, no? Yeah. Yes. Having heard learned counsel for the petitioner, from the materials as presented, it is clear that the market had been put up for auction as per permission received from the competent authority, that is the KHADC, on 22nd March 2024, and that pursuant thereto, the writ petitioner was settled with the market, with collection of market tools for the market. Stop. This court, in the usual course, would have relegated the writ petitioner to seek remedy as provided under the, take down more, the Khasi Hills District, bracket, establishment, comma, management and control of markets, close bracket, regulation 1979, wherein a petition against any order passed by the management or by an officer of the council is appealable to the, will lie before, not appealable, will lie before the executive member in charge markets. Stop. In the same vein, VEIN, the order, the impugn order being passed by the same respondent number
Number 1
should have been assailed before the executive member in charge markets. Stop. However, due to the nature of the case and the urgency, as can be seen as by the impugn notice as we impugn this, today opening the bids.
Bids released today.
Yesterday, I mean day before, wasn't it? As by the impugn notice, the settlement shall as by the impugn notice, operation of the market. As can be seen from the auction notice itself, impugn auction notice, it is directed that in the interim, the impugn notice dated 25 April 2024 issued by this aim of Nova Sopha, the impugn auction notice dated 20 shall remain stayed until the next date. Yes. List accordingly after 3 weeks. As the matter has been, as this order has been passed in the without no, as the order, sorry, the respondents also is at liberty to file for modification or recall of the order.
Highly
if so advises. Because that's the thing, that's the recourse. You've made a woman's there in the writ petition that it should have gone to the executive member in charge market.
Lordship, my case is that Section 21 will not even come to my aid.
It will come. Any order against this aim, it will come. With that, we'll see.
Lordship.
But anyway, yes. Yes. Where's that letter? I know you want to go digital, but still, paper is
My
necessary.
apologies, Lordship. My apologies.
Still, until the order records digitized.
My apologies, Lordship.
You'll be happy with that?
Yes, Your Lordship, but I just want to make one submission, Your Lordship, with regard to my service, Your Lordship. Since the government has passed an order, Your Lordship, informing that those ad hoc appointees who are appointed after 2007, Your Lordship, will be considered and examined for regularization. Until such time, status quo may be maintained. So I'm just praying, Your Lordship, that status quo may be maintained, Your Lordship. Let the government will take appropriate
cause of
steps.
action all itself, Lordship. Right now, as of right now.
Now you're not working anymore.
I'm still in working, Your Lordship. So status quo may be maintained, Your Lordship.
With regards to the, as per the directions of the Lordship.
You are not paid salary from when to when?
From November 2022, Your Lordship. I have filed my affidavit, Your Lordship, that notification in my affidavit, Your Lordship.
Yes, this writ application had been filed seeking regularization of the service of the petitioner as well as for payment of arrear salaries for the period that she had rendered service. Stop. Pursuant to an order of this court dated 18/4/2024, after taking the facts of the case into consideration, the state respondents were directed to obtain instructions as to whether the department would afford salary to the petitioner for the period that she served till date. Stop. Next paragraph. Stop. Mr. H. Karonlang today has produce a communication dated 26 April 2024 that the department is in the process for creation of a supernumerary post, SUPERNUMERARY post, and the salary of the writ petitioner will also be paid for the period that she has served till date. Stop. In view of this submission, Mr. D. Nyota praised that the writ petition may be closed only with the observation that as the regularization of these she's ad hoc.
Yes, Your Lordship.
Of temporary employees. She's temporary, or what's the appointment? Let's see as what? A temporary, yes.
Temporary, Lordship.
Yes, Thomas. Of temporary employees appointed after 2007 under consideration, that the same consideration be given to the writ petitioner should any decision be arrived at by the state respondents. Stop. The prayers allowed. The writ petition is closed, taking into account the communication dated 26 April 2024, and also the respondents are also directed to consider the regularization of the petitioner should a decision be arrived at with regard to the status of temporary employees appointed after 2007. Copy of the letters taken on board and made part of the record. Right, matter stands closed and disposed of. Yes.
Obliged.
All right.